it a contempt? Let's test it next week. Objections are not there, I suppose. Objections? Yes. Take the date. Yes. Is it a pending matter? But you said 28-4. Has it not been listed earlier? Any caveator? No caveat. That's right. They can be still a caveator. And the objections cleared? Take it. Yes. What is the urgency? This is not just tell it.
Sir. Sir, the opposite. RFA worries. RFA illness. Sir, RFA different roster.
When is the matter execution? What is the date? Next week, which date?
15th, madam.
Sure.
Next
week is not 15th.
15th is Sunday.
15th is Sunday.
Next week. 15th or 16th.
It's all right, please. Okay, take it. By any objections?
No, no.
Yes, after
Objections.
After 2 weeks. Just say any objections, everything. Yes, ma'am.
My lord, this is a 2018 matter, and water is not supplying to other than Kamal Nagar.
What is the nature of the, is it an appeal or what?
Appeal.
Which appeal? Commercial appeal? What appeal? RFA? Writ appeal?
Public interest litigation.
You just
Visitation,
give
my
that.
lord,
Just take
visitation.
it.
WP. Kindly have it next week, my lord.
That's Why was it not listed since 2018? When was last listed? You file an early hearing. Give a copy to the other side. File an early hearing application, not through memo.
Yes, sir. The member for who is spoken to my lord.
Just see it, what is spoken.
The matter was dismissed for non-prosecution because I did not appear on one date, my lord. No, I have filed an IDA for recall of the order matters.
That's for recall of that order. Just I will see.
Anytime this week or at the time of the of this court.
Is it our?
It's a PIN, my lord.
But you serve.
It has not come up even once for hearing, my lord. That's it.
But we'll give you a date, inform the other side.
The other side is not yet, it's not even come up before the court on one date also, my lord. So it's a fresh-
2018, you have not got it listed?
No,
Oh, sorry, 24.
It has been listed
Oh.
at least 6 times, but not at
Okay,
this matter.
okay. Let's give it.
Anytime next week.
Next week, next to next week, any day.
We are for the APMC matter. Single judge order we preferred a writ appeal 2024 matter. And because of the single judge's order, we are not able to make allotment process for the shops in the APMC market. The trader who responded.
Objections clear?
Here, there is one objection, that is color printout of the photo not being noticed. But since this was a respondent brief, we do not have to
Just take that. Because.
My lord, this is a commercial appeal. It has been filed in.
Yes, ma'am.
My lord, it's a commercial appeal. It has been filed in January, but it has not been listed till date.
You clear the objections?
Yes, my lord.
What is the urgency?
Lord, the company is undergoing liquidation, the applicant company. The liquidator wants to finish.
Was it before NCLT?
My lord, this is an arbitration appeal.
That's right. Arbitration. Who has filed the appeal?
My lord, the company which is undergoing liquidation is filed here.
Who, through the resolution professional or through the liquidator?
The resolution.
Resolution. Just take it. And let's
Lord, maybe have that 11th or 10th.
just check up that.
13-6.
Any other mentioning?
My lord, contempt, if I'm,
What is the,
It was an execution order, but due to some attachment, there's a miscalculation of the attachment. So hence for the memo agency for tomorrow.
no, is it a fresh appeal?
Yes.
Against which order you have filed this appeal?
For execution.
Execution, against execution order?
Yes.
It's our poster, man.
Commercial.
Is it filed under section 13 of the Commercial Codes Act?
Yes.
Is it maintainable against an execution? How? Okay. We will see objections removed.
Yes, okay, no, sir.
Caveated there.
Yeah, no, there is no case. No objection, no case objection.
What about caveat?
No case.
Just give it up. When is the execution there? When is the execution?
It's already got the execution. It's already got it. I have no idea.
What is the ground for mentioning?
For stay order.
The right for what reason?
The appellant is not in possession.
What is the urgency? You should say about.
Garnishing the image of the
Have
appellant.
it after 2 weeks. After 2 weeks. Yes.
Contempt matter.
Contempt. What is the contempt alleged?
Contempt, we have made the representation before Tahsildar to conduct a POD.
What was the direction?
Direction to hear the repetition we have
When
filed.
was the order passed?
Single bench we have filed here.
When was the order passed?
Fresh,
Hello, sir. Single bench.
Then we are alleging when is the order passed by the another single judge? Which date?
Sir, single judge order ಯಾವಾಗ pass? ಅದು ಯಾವಾಗ order pass ಆಯ್ತು ಅಂತ?
Just take that memo. Just check up which is the order date. Yes.
my lord, this is a part heard matter. It's an MFA, my lord. MFA of the year 2019. It is part heard by my lords and Honorable Justice Rachaya, my lord. In this matter, the appellants in a related proceeding before the Honorable Supreme Court have undertaken to withdraw this present appeal. But they have not filed the memo. I have filed the order.
Given a date also.
The date was actually given by this Honorable Court, but the matter was not listed after that, my lord.
What was that?
The date was given of 28th April, but the matter was not listed after that, my lord. Part heard.
Was it listed on 28/4?
It was not listed on 28th/4, my lord.
Why didn't you mention?
Then
it?
thereafter, what has happened, my lord, may I make a mention? On 21/3, the appellants had undertaken before this honorable court to submit orders passed by the Honorable Supreme Court. But after that, the matter was not listed in the vacations. It was not listed, after that, it was not listed on 20th.
Mention also.
And no, thereafter, the vacations took up, my lord, and since it was a bench to be constituted specifically, my lord, therefore it is not listed. Therefore, I'm moving the matter today.
The other side.
The other side, the appellants, I will inform them, my lord. I have been requesting them to file a memo.
Something come after lunch, mention it before there so that they also know.
I'll keep them informed.
Better would be that.
I'll move the matter.
They have given a statement before the Supreme Court to withdraw it.
They have undertaken, and as a matter of fact, the Honorable Supreme Court has directed them to undertake, to withdraw the proceedings at the earliest.
Here,
These proceedings, my lord.
mention it before, after lunch.
I'll make a mention at 2:30, my lord.
Because do one thing.
My lord.
You move a memo before the registrar judicial. Okay, then possibly through administrative order it can be listed. That's what.
I will.
But this is not the combination.
It is not the combination. I will move a memo before the Honorable Registrar. Grateful.
That's better.
My lord, this is a writ appeal against the order of the learned senior judge. This is a transfer order, my lords, passed by the corporation, which is the appellant here. What has happened, my lords, is that there is a stay on the said transfer order, which is leading to two administrative difficulties, my lords. First is that because of this stay, there are two HR professionals in one.
Is it by the KAT?
No, my lord, this is before the learned single judge. This was a writ petition.
Writ appeal.
Yes, my lord. Writ
There is
appeal.
a stay of transfer.
Yes, my lord.
What is the difficulty it's causing?
My lords, the difficulty it's causing is that there are HR professionals which two of them are in one location, my lords, while some stations of the corporation, there are no HR professionals because of the transfer order.
Totally unrepresented.
Indeed.
Objections clear?
Objections clear.
Caveat?
Yes. Caveat is there, my lords, we've served them, we've informed them, my lords, that memo.
Inform it, just take it next week. Interim.
My lords, for the appellant in this matter, I'm for the appellant in this matter, my lords. It's an RFA matter.
RFA,
Yes, my lords.
not
Sorry.
here.
Sorry.
It's a different bench. Just check up. Pardon? What is the contempt alleged? When was the order passed? 22nd? 20? So, we'll file against that order. Just take it, ma'am, after 2 weeks. Yes. Second appeal. Just one, just second appeal. No, you have to go a different bench.
23-6.
Yes.
123 writ petitions.
Contempt is our jurisdiction.
Now, this is a contempt petition. The order was passed in
19-6.
23/12.
Take that also, ma'am.
23.
Take that also.
Sir, write your names. Your names.
Follow the list.
My lords, if I may
Serial
mention a
number.
matter, my lords, if I may mention a matter, my lords, serial number 68, my lord, the government respondents, they have filed a memo along with the report of the surveyor, my lord.
Which number? Is it part of today's list?
Yes, my lords.
Which number?
68, my lord. The government, they filed a memo along with the report of the surveyor and tahsildar.
Ashok Acharya.
Yes, my lord.
Yes.
The government have filed a memo along with report of the surveyor and the tahsildar regarding the whether the school building will be within the buffer zone or not. I'll have to file my objections to it, my lords, because that
Can
is.
you appear? Yes. He wants to file objections. You have filed anything? Just say that the counsel for the petitioners states that he intends to file a response to the memo filed by the respondents.
Yes, ma'am.
Official respondents. Be filed within 4 weeks, list comment.
Sixteen seven.
Much obliged.
Item number 67, my lords, I appear for the petitioner. Lords, respondents, my lords, are represented by the, my lords, government advocate.
57,
67, 67.
7 yes.
Lords, I'm filing an amendment application today. I will serve it on. I'm filing, my lords, an amendment application.
Okay.
I will serve it on the other side, my lords, and I will.
Request of counsel for the petitioner adjourned to.
May I request for, my lords, any,
17-7.
please.
Serial number 23 and 25, my lord.
Just wait, we'll just run through the list.
Serial number
Just
1.
wait.
Yes.
Here for appellant in this case, Lord.
Yeah, objections.
Not that. One objections has been complied, another 3 objections are there. I'm seeking for a
Objections
week's
we
time,
remove
Lord.
within 4 weeks.
1 week, Lord, in my absence, Lord.
We'll give you 4 weeks. Okay, make it 2 weeks. Yeah, 3 weeks.
Permit me to move the memo after compliance of the office objection.
We are giving you a date. Before that, do it. 3 weeks.
2 weeks, Lord, because only 3 minor objection, already one complied, Lord.
We have to see our board also, please.
2-7.
Next.
Serial number.
15 days, 2/7 is it. This month only, Lord, because for an urgency, Lord, because the PDCL matter, Lord.
Why didn't you, when was the last listed?
But in vacation 29th, Lord.
Just have it this month, 30th of June or so.
30th June.
Yes, next.
Serial number 2.
Yes, Mr. Gunjal, you have many matters today.
Then I'll make myself clear. My 257, 849, 50 are together. The objection is, Lord, the second set is not filed of the claim petition. That's all. And I've got the copies here, my lord.
Just show us this also. CPC. So
Could it,
what
could it
orders
be
you are
passed over?
managing?
I'll size your lordships here. Lordship may pass over and take it along with 49, my lords.
So we'll take it up along with 49.
With 49, my lords. And 5, 7 and 8 also are the same, my lords. I'll wait here. I'll
Take it along with 49.
Pardon, my lord?
We'll take it along with 49.
Please, my lord.
Serial number 3.
For the complainant petitioner, your lordship.
Switch on your mic.
Your lordship, on the last occasion, on the 22nd, I think during the vacation, 7/5, the court had directed me to keep the child present before the court. Child to come all the way from Mumbai.
Why was the child
If your lordship, Lord,
If I may.
what? No, your lordship, will kindly see. What happened was, here, the mother, your lordship, can I file my objections, Lord, if I, over the counter? No, what has happened? They were married, and they were living together in Bangalore. And they had an apartment in somewhere here in Bangalore, and which was on EMI. Subsequently, what happened, my lord, the monthly EMIs was some 70 odd thousand rupees. And the petitioner, my lord, the petitioner was earns about 4.5 lakhs of rupees, the software engineer. And differences cropped up between the couple. And then what happened? He just abandoned the family on 15/8/2024. Left. No. Let me mention.
really meet our observations also?
Yes. Yes. According to them, the child was removed from the custody of the court on 27th. Your lordship will kindly see. But that's the reason I'm saying, my lord. See, they had filed an application. I'd filed my objections to that application, and that application I had very clearly said that because the bank, my lord, was threatening to lock the apartment, to seize the apartment, because EMIs were not paid. She couldn't afford to pay 70 because she herself was earning some 85,000-90,000 rupees, so she couldn't pay the EMI. No, 27.
If your lordship may see, in mark page 69, wherein I would like to illustrate.
See the order of the lower court, which restrains them to take the
Page number 78, your lordships. On the last paragraph, the respondent is restrained from taking away.
What is the date? 27/3.
27th.
Now, did you file any response to this application?
Yes, my lord.
Where is that response? And or show from the order.
Yes.
Suppose you stand before the trial court.
My lord, your lordship, can you turn to the next one, my lord? The next, I have filed my counter, 89, your lordship, kindly see. 89, at page 7, at page 90.
90.
Page 90, without prejudice to what is stated above. Or, your lordship, can I read para 6, my lord?
Yes.
Can I read para 6? With regard to the amendments made in para 8 and 9, this response submits that the petitioner may be permitted to visit the child once in 2 weeks, preferably on Saturday and Sunday between 3 and 6 p.m., subject to the willingness and schedule of the child. If there are any trips or family functions planned, the dates shall be accorded electronically with mutual understanding. As far as custody is concerned, the respondent submits that during summer vacation, the respondent shall take the child to Pune for 10 days, and the petitioner may be permitted to take the child in the evenings in the morning between 11 a.m. and return her to the respondent by 6 p.m. every day, subject to willingness and schedule of the child. If there are any trips or family functions planned, the date shall be adjusted accordingly with mutual understanding. As far as permitting the petitioner to take the child in the month of September 2025 to Disneyland on the occasion of the 5th birthday is completely ruled out, as the child would be in the midst of a scholastic year, which would hamper her studies and well-being apart from disturbing her extracurricular activity which she enjoys. While considering the prayer made in the application, the observation made by the Honorable Court at Pune, and while deciding the application for visitation rights of the minor and the conduct of the petitioner which has been considered by the court may be kept in mind. Considering the aforesaid behavior of the petitioner over the period of time, as observed by the Honorable Family Court at Pune, the respondent apprehends that the petitioner may remove the child Miraya out of the jurisdiction of the Indian courts, consequently depriving the respondent of her daughter. Miraya, it would be Miraya, it would be in the best interest and best and paramount interest of the child that the visitation rights may be ordered as suggested by the respondent. The petitioner may be directed to deposit the passport of the minor child with the court in order to ensure that he does not remove the minor child out of the jurisdiction of the Indian courts. The application may be allowed so to that extent. Now, your lordship, kindly see the next one. The apartment in Bangalore where the respondent was residing was jointly purchased by the petitioner and the respondent by availing a loan. Monthly EMIs to the tune of 61,230 was to be paid by the petitioner. Since January 2025, the petitioner refused to pay EMIs, and not only EMIs, my lord, even the society maintenance he refused to pay. And inform the bank accordingly. The intimation of the petitioner to the bank is produced herewith for perusal of the Honorable Court. Since the petitioner stopped paying the EMI, the respondent paid a couple of EMIs from her meager salary. Being unable to pay the EMIs and also pay towards her household expenses, the petitioner stopped paying the maintenance since January 2025. The bank has been calling the respondent regularly to make good the EMIs, failing which they have threatened to take possession of the flat and seal the same. Being left with no other alternate to survive, the respondent has sought for a transfer of her job to Mumbai and has been granted the transfer. The transfer confirmation of her employer is produced herewith, so and so, so and so, so and so. This was, my lord,
Post IA number 3 was filed here. Post IA number 3, the order came, this was passed. If your lordship could see, objections filed by the respondent to IA number 4.
Lord.
IA number 3 came out on 27/3. The date of filing, if your lordship may see, inked page number 69. The date on which the application is filed is on 7/3/2025. This is IA number 3, very specifically. What my learned counsel is stating is objections to IA number 4 post the order dated, your lordship.
No.
Yes, your lordship.
In the meanwhile, your lordship. No, this is not
Yes,
the stand,
please, your
but your lordship may kindly see. That's the reason, my lord. The child was not removed. The child was not removed from this court, prior to the order. See here, lordship may kindly see. I have, because the child had the bank was threatening to seal the apartment. Yes.
Surely you have shifted to Bombay.
Can you just? Yes.
Was post 27/3?
22nd.
No, that's not the stand which you have taken. The child has been sent on 22nd.
Child has been sent on 22nd, and I shifted on the 27th, just before the court order was passed on the 27th. No, at that point in time, my lord, this was at that point in time when this objection to IA 3 was filed. That was not the concern. That was not the threat. Subsequently, my lord, as the banks, as a matter of fact, your lordship may kindly see the. Can I just persuade your lordship to have a look at this? Can I have a persuade?
Was it an oral order or a?
No, it's a standing dictating order, your lordship.
No.
Yes, your lordship.
That was on the 27th. In the meanwhile, my lord, your lordship may kindly see the child was.
Simply asking this.
Yes.
Was it an oral order or a reserved order?
Which one, my lord?
27/3.
27/3, my lord, is.
It's a written order.
Was dictated in the court?
Yes, please, your honor.
Restraint from taking the child away from the without the consent and bribe. But this was on 27/3. 27/3.
Listen to us.
Yes.
When on 27/3.
Yes.
Order is being dictated in the court.
Yes.
Not to take the child away out of the jurisdiction
Yes.
of the court.
Yes.
They pointed out to the court, look here.
I brought it to the notice of the court.
Where do you say so?
I brought it to the notice of the court, my lord.
When?
See, but during the when.
Say so. Where do you say so? You have brought to the notice of the court that on 22nd 3 itself, the child has been taken or has been sent to the grandparents.
If your lordship may allow me to submit, in fact, the respondent has filed the objections on IA number 3 on 11/3, wherein no such facts have come up before the court.
It's a post 11/3, na? 22nd they have.
Yes.
But 22nd
Yes.
and the fact situation was in existence.
No.
Why was it?
See, my lord, what happened was this, I think these objections were filed on somewhere on, I don't know when, I don't remember the date, 11/3, March. Then the matter was heard. While the matter was pending, we had the threat from the bank, and that's the threat from the bank. My lord, it was, my lord,
Listen to the court, please.
yeah.
We are testing your argument that you have taken away the child to Mumbai or sent the child to Mumbai on 22nd 3.
That's right.
Very right.
Yes,
Court says you will not take away the child out of the jurisdiction on 27/3.
27/3.
Was it not an obligation on your part? To say,
My lord, when this matter was pending, I had brought to the, as a matter of fact, my learned friend is aware, I had brought to the, between 22nd and 27th, he had moved another application. This application, my lord, IA4 was moved. At that point, I brought it to the notice of the court. What it was, between 22nd and 27th, I brought to the, orally I brought to the notice of the court.
what was the proceedings between those dates?
My lord, they filed another application. They filed an IA4, they filed.
If your lordship may allow me to address the court.
How was the child sent to Mumbai on 22nd?
Sorry, my lord?
How was the child sent?
By flight. I have the, my lord, I have the,
In fact, they have changed the school also, your lordship.
yeah, my lord, 22nd, I have two sets, my lord, one for each of your lordships.
If your lordship may allow me to illustrate the court.
Yeah, cyber code. 22nd, my lord, 22nd, your lordship, can you see, 22nd, the child was sent to Mumbai, document number 2, my lord. And your lordship, can you see document number 1? This is the letter written by in January, my lord. In 8 January, your lordship, can you, may I paper for, hello, chief manager. According to the attached screenshot, my wife still has not paid any amount towards a home loan in spite of my previous email dated so and so. Going forward, I'm expecting her to make the entire payment towards the loan since she is occupying the house and also has made negligible payments towards the property in the past. I will not be making any payments towards this loan, home loan. My lord, she was left high and dry. And that's the reason, my lord. And the child was sent to Bombay on 22nd with her grandmother. And subsequently, my lord, she shifted to Bombay. There's no contempt. I can understand if I had done this subsequent to 27/3. This was done prior to 27/3.
You just see page 2. That's the boarding pass of the child.
Your lordship, all these things which they were never produced before.
That's what we had asked him. But the fact remains as a fact, 22nd she had already gone to Mumbai.
Yes, when the matter.
Maybe not brought to the notice of the court. That's what we have put it. But as a fact, that 22nd, the child was sent to Mumbai.
Yes, under the garb of going to the grandparents' house, your honor.
Whatever may be the reason.
Yes.
And would not be taken away. So by that time, possibly you were privy to this information that she has been sent to Mumbai.
Under the garb of going to grandparents' house.
You were on 27. Were you aware that child is not in?
Yes, the opposite counsel made a submission before the court. We acknowledge that they have gone under the grandparents' home, your lordship.
Brought to the notice of the child and the court would not.
The submission was grandfather's house, your lordship. We thought they'll be coming back. They'll be returning back because there is a open order by the court.
The order is you will not take away the child from the outside the jurisdiction of the court. But by that time, 27th, actually the child was outside the jurisdiction.
That's right.
But
so now, in this background, what do you say?
Further, 2 more orders have been there in continuance to that, your lordship. Those 2 orders also have become infractious. First, the school has been changed, wherein IA number 4 gives the visitation rights according to the old itinerary of the school which the girl was residing at Bangalore. Based upon that, the order was given. Now, since the school is transferred, the whole itinerary changes, Your Lordship. Yes, without the consent of the court, without the consent of the petitioner.
How could I live here in Bangalore without a house and with a small child?
If Your
So
Lordship,
now, my lord, I've shifted to
if
Mumbai.
if I may submit,
I'm living with my parents, and I put the child to a.
if Your Lordship, if I may submit, the same respondent has gone before the Supreme Court, stated that I am a permanent resident of Bangalore, filing a domestic violence case, getting the case transferred all the way from Mumbai to Bangalore, Your Lordship. Post that, yesterday, the recent development is they withdraw the domestic violence case, Your Honor. Yesterday, they withdraw the domestic violence. Wherever the petitioner is ready to fight the case, according to her, it is literally sort of hit and run, Your Lordship. In fact, even the complainant petitioner comes all the way from Mumbai for every proceedings, Your Honor. I'm ready to.
He is a resident of Mumbai?
Yes, yes, Pune. Yes, please, Your Honor.
So in any case, shifting to Mumbai, possibly we don't know. Well, the matter got transferred after the orders of the Supreme Court.
Yes, please.
You can rethink of it. Maybe you want to send it back to the matter to be there in Mumbai, or possibly that will be nearer to Mumbai.
No, he's ready to fight it out here at Bangalore, please.
That's up to you. We say nothing. Now, what is the contempt alleged? Contempt alleged
Yes.
in violation of 27.
27.3 and IA number 4, IA number 5, which are infractious, Your Lordship, as the itinerary has changed. The girl has been sent to.
What is the order in IA4?
IA4 is, my lord, the visitation in Mumbai. Lordship, kindly see this. Very interestingly, my lord. Look at the order passed in that.
Yeah, just come to that.
Very interestingly, my lord.
Which page?
Page 129, 128. I would say the last paragraph. 128, Your Lordship, may kindly see. There is absolutely no contempt. During the, can I, Procedural 128, last. During the pendency of this petition, the petitioner has granted fortnightly visitation rights on the first and the second Saturday in between 11 a.m. and 6 p.m. with permission to take the child with him from the house of the respondent at 11 a.m. and hand over the child to the house of the respondent on the same day at 6 p.m. either in Bangalore or Bombay. So that has been complied with. He has been meeting the child in Bombay.
Your Lordship, weekly thrice, the kid has been put.
Yes. So did the father meet the child?
Yes.
In Bombay?
Yes.
Only a few times, Your Lordship.
And which is the other order of which this appears to be in IA5 or IA4?
This is IA4.
And what about IA5?
IA4 and 5. My lord, they should pass a common order.
Common order, Your Lordship.
Common order, IA4 and 5.
So now what is your allegation for violation of IA4 order?
IA4 order, the whole itinerary, as Your Lordship, I stated, is changed, and post the summer vacations have been changed, and during the present summer vacations, the child's timetable has been changed.
We will go by this order.
Yes, please.
So this order says that you have a visitation right on Sunday, first and third Sunday.
And during the summer vacations, every day, Your Honor.
You can meet the child either in Bangalore or Bombay.
Yes, please, Your Honor.
Okay. Now, is there any violation insofar as these orders?
Yes, please, Your Honor.
What manner?
Weekly thrice, the kid has been put to two or three extracurricular activities where almost 4 hours is gone, wherein I won't be able to have my time with the kid, Your Lordship.
No, but this order is there from 11 a.m. to on first and third Sunday. First and third Sunday, you have the visitation rights.
Yes.
Am I right?
Yes.
This is what the order says.
Yes, that is IA number 6, Your Lordship.
That they have not implemented this order, they have denied the visitation rights to you.
Yes, please, Your
On
Honor.
which dates?
First and third is pertaining to IA number 6, Your Lordship.
This is what we have been told. What is the order of which contempt is alleged?
If Your Lordship may see 126, wherein the order states on the last second para, page number 126, the petitioner is permitted to take the minor daughter at 11 a.m. and return her to the respondent by 6 p.m. every day from the house of the respondent, either in Bangalore or Bombay, wherein child is residing, subject to schedule of the child. And if there are trips or family functions planned, the date shall be adjusted accordingly with mutual understanding of the parties during summer vacation. Your Lordship, without the consent or without having 126, your lordships.
Which paragraph?
Post 29th para, therein which states order, IA number 4 filed by the petitioner under.
Just read it once again.
IA number 4 filed by the petitioner under section 26 of the Hindu Marriage Act 1955, read with 151 of CPC, are hereby allowed in part. The petitioner is permitted to take the minor daughter at 11 a.m. and return her to the respondent by 6 p.m. every day from the house of the respondent, either in Bengaluru or Bombay, where the child is residing, subject to schedule of the child. And if there are trips or family functions planned, the date shall be adjusted accordingly. Your lordship, I would like to emphasize, with mutual understanding of the parties during summer vacation. Here it is a one-way transaction wherein the mother has taken the decision on behalf of the kid and put weekly thrice, wherein 4 hours of 11 to 6 is gone by the petitioner, where he can't have the time with the daughter, your lordship. And multiple trips planned across.
This order is not challenged. This direction is not challenged.
Post this order, your lordship, the vacations came and I'm on a.
You are seeking implementation of this order.
Yes, please, your honor. Yes, please, your honor. And undertaking that the summer vacations.
That's one thing. Any time have they denied you the visitation between 11 a.m. to 6 p.m. every day from the house?
7 to 14th May, they have done it, your lordships.
7 to
6th to 14th of May.
6 to 14.
Yes, please, your honor.
After that, he went to the US for 10 days, 10, 12 days.
Without mentioning.
12 days, he's gone to US. He's just come back.
Tell us one thing.
Yes.
There is an order now.
Yes.
Not challenged either by either the party.
No, none.
Need to be implemented.
My lord, it's been implemented in letter and spirit. In letter and spirit, he's been,
So we take it. You will implement it in letter and spirit.
yes.
Yes, please.
For
Yes,
when
please.
this order stands.
Yes, please.
It need to be implemented.
Yes, please, your honor.
So you are agreeable, we will record the statement that this order would be implemented in letter and spirit. No violation.
Please, your lordship.
That would satisfy you.
My lord, what has happened? Now the summer vacations are over. So that's
He has summer vacation for a particular.
that's right.
That's over, but in any case, he has visitation rights every day also.
Yeah, no. See, the thing is, my lord, that visitation, that's only during summer vacations. Only during summer vacations.
Could be other than summer vacation. What are the?
Every fortnight.
Every?
Fortnight.
First and third Sunday between 11 and 6 p.m.
First, and your lordship will get it at 128. Yes, that I will comply.
The later part of
Yes,
the order.
yes.
It's the regular visitation. Yes. An undertaking may be given by the council. That's all your.
My lord,
Your lordship,
see, the thing
we
is,
would
my
like
lord,
to
I'm
clarify one thing, decision which is taken by the petitioner where the school is changed and the.
That is not within the scope of this.
Please, your lordship.
And the child has been shifted to Bombay on 22nd, much before that order was passed. It can't be, made to sit at home. Let the child go to the school. Let her enjoy her childhood. What do you want? She should be brought back in Bangalore and put it in a school here.
And you are staying in Pune.
in a boarding.
And you are staying in Pune. And mind it, this order also contemplates or acknowledges the child is in Bombay. That's the reason say Bangalore or Bombay. Getting the point?
Yes, please, your lordship.
Ultimately, the interest of the child, which is.
Please, your lordship. Yes,
Let her live her own life. Let her enjoy with her peers.
please, your lordship.
Okay, better would be with the child. Child goes to the school. Don't restrict her not going to the school.
The child has been falling sick after possible.
We'll have visitation. If you any order, you can go to the court concerned and seek whatever order you want.
Modification.
We are only concerned with the contempt jurisdiction.
Yes, please, your lordship.
Not their statement. Insofar the later part is concerned, that will be implemented.
Yes.
Please, your
They can't say no. Let's be very clear.
Please.
Lord, I've never said no to them.
All right.
That every fortnight, the child can definitely go. You have to. Lord, one more thing. I don't know if it's apt for me to. This relationship, Lord, has gone too far and beyond repair. I think your lordship could suggest a mediation so that something can be done so that the agony of both the couple and the child is mitigated.
Have you spoken to your learned
I
friend?
have told him a couple of times.
Yeah.
I've told him a couple of times, but I don't know. I know what their stance is. But this is my stance.
Have you discussed with your client?
Yes, please, your lordship.
What he's suggesting?
Yes, please, Your Honor.
Lord, as a
Lordship.
matter of fact, I've been magnanimous.
They say the custody of the kid is uncompromisable and they want to hold the custody of the kid, permanent custody, Your Lordship. Apart from that, any monetary relief, they're ready to pay, Your Lordship.
You work out the solution for that. How long you are going to fight again?
That's exactly what I told him.
Please.
Lifelong. You are free to do that. If you are happy with that, you can do that.
No, please.
Suggest for your own benefit,
Please, Your
for
Honor.
your own
Lord,
welfare and
as a
peace.
matter of fact, I have told my learned friend, this is
Go for a mediation.
this is a girl
Please,
child.
please, please, Your
And the
Lordship.
girl child requires
No, with the
requires
total-
guidance of
if-
the mother.
So the custody of the child also.
If Your Lordship may allow me to submit one thing, it is not proper for me to state as to what grounds the petitioner is deeming fit for him to have the entire custody of the kid. It is not a matter which I can state it before the open
There's
court
nothing,
with much.
there's nothing to it, my lord.
Tell it at the time of the
My lord,
discussion.
I mean, the most innocuous things has been having produced before the court. Anyway, that's not the bone of contention here.
We will not enter into that.
Yes,
You
that's
yourself-
not the, that is not the,
Even suggesting you to go to the mediation is also
No, my
not
lord.
our brief. We only, with the welfare that, with the view that the child should not suffer.
My lord.
We have told you.
My lord, your lordship, I kindly see my
Ultimately,
objection.
choice is
I've said
with
in
you.
the
Yes,
interest
please,
and
your
wel-
lordship.
In the interest and welfare of the minor child, I've said that. In the interest and
Your Lordship, another submission, we would like to have the itinerary of the new schools, kids' new school, which we don't have it in
that
possession.
I'll ask my client to, convey it to him.
This contempt petition has been filed. We will have the following figures. We have heard on the last date of hearing, this court had directed the presence of the child before this court today. The child has been produced. We have heard the learned counsel for the parties. Insofar as the challenge to the insofar as the allegation of contempt relating the order of 27/3/2025 is concerned, the stand of the respondent is that the stand of is concerned, the same is primarily that the child has been taken outside the jurisdiction of this court. Post 27/3/2025. The record suggests today the learned counsel for the party, the respondent has filed a counter stating that the child was sent to her grandparents in Mumbai on 22nd
March.
22nd of March 2025. That is before the order of 27 March 2025 was passed. And hence, in that sense, there is no contempt of the order of 27/3/2025. In fact, during the course of hearing, the learned counsel for the petitioner conceded to the fact that such a plea was urged by the learned counsel for the respondent before the court concerned when the order dated 27/3/25 was passed. The other submission of the learned counsel for the petitioner is that the later part of the order dated 27/3 later part of the order dated 25/4/2025 that the petitioner is not being allowed the visitation rights granted by the court below on first and third Sunday between 11 a.m. to 6 p.m. With permission to the petitioner to take the child with him from the house of the respondent at 11 a.m. and hand over the child to the house of the respondent on the same day at 6 p.m. That's right?
Yes, please, Your Honor.
Either in Bangalore or Bombay, where the child is residing. Concedingly, the child is residing in Mumbai. The learned counsel for the respondent on instruction states the said directions of the family court Bangalore shall be implemented in letter and spirit. Submission is taken on record.
That's between every fortnight, my lord. Your lordship, kindly clarify.
That's the reason we have said first and third Sunday.
With respect to the summer vacations.
Summer vacation is spent.
You have to see this summer vacation is gone. You have to see fresh direction. Was this summer vacation meant for future also?
No, with respect to,
Past. Summer vacation is gone now.
no, it is still there in existence with the new school.
I believe the
Mumbai.
Schools reopening on the 12th of
12th of
June.
Till then, at least, Your Lordship.
Summer vacation has come to an end?
Yes.
Or no?
Yes.
No, no.
12th of June, the school reopens.
Until
12th
12.
of June. So
Yes.
there are still some days.
Yes, please.
Another week.
Now, fella, before 12, when can we have?
Every day, Your Lordship, the order.
Every day.
tomorrow, when we reach.
You will go, can you go every day till 12th? After 12th, this first and third will come into play. Full stop. As we note that visitation rights were also allowed to the petitioner during the summer vacation. We are informed that the summer vacation shall come to an end on 11th of June.
11th of June.
11th of June.
Yes, schools reopen the 12th.
The reopening day. It is agreed by the counsel for the respondent on instructions from respondent that the petitioner shall be at liberty to have visitation rights on every day. On every day till 11th of June. 11th of
My Lord, suppose the child is not well for any reason.
As ordered by the family court in paragraph 29, earlier part of paragraph 29, which confines to the visitation rights of the petitioner during summer vacation.
Please,
That's right?
please, Your Lordship.
My Lord, suppose the child is not well, that also may be.
See, let's be very clear.
Please, Your Lordship, this
This
conduct.
you will foresee everything happening.
Anyway,
That
I'll
will
leave it at that.
I will not take it.
No, I will not, I'll leave it at that. I'll leave it at that. Yes.
It's a father. Let him
No,
have the
we
child
have,
also.
matter of fact, I've been magnanimous, my Lord.
Yes,
Lord,
yes.
kindly see my,
Don't say that.
it is right, it's his father, I'm a father myself, it's my right, it's the father's right.
Thank you. Contempt is disposed of.
Grateful, Your Lordship.
Contempt is closed. Next.
Serial number 4, Ritesh Kirira.
Here for appellant, my lord. Lordship, copy has been served through email and MI has been filed, Lordship.
Yes.
Lordship, copy has been served to the respondent counsel and through email and memo has been filed, Lordship.
But there are certain objections.
We'll comply that.
Objections be cleared within 4 weeks.
Lordship, may kindly have it done tomorrow.
What is the urgency? Just everything certain because.
May date may be
10/7.
10th of July.
much.
Serial number 5. Serial number 5, 5 to 8, sir. Serial number 9.
Lordship's kind
Serial number
permission.
9, Shabina.
I am for the respondent in first case. In the second case, I am the. In the second case, they have to file objections, my lord, to the content.
Just say that none for the respondent. No, you are appearing for the petitioner in the first case.
The second case petitioner, first case, I am the respondent.
Okay, you are the respondent. Who is appearing?
First case.
You are appearing for Miss G,
Complainant.
Shri G.
Hemanna and others.
Hemanna.
Please, my lord.
You have to file objections.
Please, my lord, in the connected matter.
The counsel appearing for the respondent in CC 118 to 24 states that he shall file objection within 4 weeks. Rejoinder, if any, be filed within 2 weeks thereafter. List on.
22/7.
Please, obliged.
Obliged.
Serial number 10.
Yes.
Shisuddin.
For the complainant, my lord. For the complainant.
What
There
do you
is a week's
say?
time.
Pardon?
Pray for a week's time, my lord.
For what?
Senior is not in station.
At the request of counsel for the petitioner, adjourn to. Give it.
15/7.
Next.
Serial number 11.
Who appears? There is no reply here.
11.
I'm appearing for the accused number 1. My lords, we have preferred a writ appeal challenging the order, my lords. It is being listed on 12/6, my lords, before my lords.
Just say this, re-notify on 12/6.
Please, allow.
Serial number 12. Yes.
I'm for the complainant, my lords.
Joint complaints had to be done along with accused number 1, my lords. I'll take it up. At the request of counsel for the respondents, adjourn to
16/7.
Much.
13. Siddharth Shishkumar.
This has to be argued. This has to be argued now.
NOC has been given, my lord.
Pardon?
NOC for appellant.
Is that, ma'am?
I filed no objection. Memo for retirement.
Memo for retirement. But who is appearing for the petition, appellant?
Siddharth.
Hmm? Who will appear? See, you must make someone appear for the appellant, then only we will allow you to retire. Not even signed also. Just give it back, ask him to sign this.
Somebody else has to file.
The counsel for the appellant has filed a memo for retirement. Appropriate shall be that he shall ensure representation on behalf of the appellant on the next date of hearing. Let there be an advocate, then only we'll allow you. Okay, or the appellant's representative must be here.
22/7. 14. Serial number 14. 14. Shri Baskaraja.
None for the parties adjourned to.
4/8. 15. Serial number 15.
My lords, we are for the accused, requesting for 1 week time to comply with the office objection with respect to the compliance affidavit which we filed.
You got the compliance affidavit?
I have received.
What is your stand on that?
Notes, they have already complied, but it's not on a time-bound manner, my lords. After lapse of 6 months.
But they have complied with the order.
They have complied.
What
There
remains?
is a stay before the commissioner.
What remains?
It may be disposed.
Just say this. Learner counsel for the petitioner states that though the order has been complied with, but with some delay. Full stop. In view of the submission made and the fact that the order has been complied with, he states he shall withdraw the contempt petition.
Yes.
Dismiss as withdrawn.
16.
Complainant.
I'm appearing for the accused, my lords. Filing my statement of objections.
Just give it to him.
My lords, copy has been served now.
What is your take?
My lords, complied? No, my lords.
Here, what has happened, my lords,
Then
against the
just show
order
the
of the
file.
AC, my lords, we have preferred appeal before the deputy commissioner. That is still pending for consideration, my lords.
No, but tell us one thing.
Please, my
What is the order?
My lords, AC has passed an order, my lords, for maintenance of 6,000, my lords. Actually, what has happened, my lords, against that we preferred writ petition, my lords.
The contempt is against the order of the single judge.
Yes, my lords.
Please, my lords. And let me-
So now deputy commissioner is seized of the matter.
No such documents have been produced, my lords. My
And
instruction.
this interim order was to continue till 6 weeks.
Please, my
Yes.
lords.
So what is the contempt alleged?
My lords.
My lords, contempt alleged is, my lords, she was put in back, there was a direction by this honorable court by passing an order to put the senior citizen, that is the complainant, back to the premises, my lords.
Where is that order?
My lords, that order is at page 41, my lords, annexure E. Page 42 is the operative portion, my lords. Now, pursuant to this, my lords, she has been thrown out. And there is
What do you
also-
say?
My lords.
You
actually,
represent whom?
accused, my lords. She is the daughter-in-law, my lords. Here, what has happened, my lords? She is having 2 children, my lords. Both are minors. She has to take care of the children also, my lords. Here, mother-in-law and husband, my lords, they came and stayed with the accused, my lords.
No, it's all right,
Because-
ma'am. We are concerned with the contempt. Now, this obligation is on the respondent or on the police authorities?
Respondent, my lords. Accused.
You see page 42?
Yes, my lords.
Now, the obligation is on whose part?
My lords, the police has, my lords, took the complainant and put her in possession of that property, my lords.
Okay.
Later on, my lords, after 2 days, she has been thrown out. Subsequently,
By
my
the
lords-
respondent?
Yes, my lords. And there is a direction by the Assistant Commissioner to pay maintenance of
When,
6,000.
when was that? After 7 June
Yes, my lords.
and before,
The order passed by the Learner Single Judge.
before 3rd June of 24?
Yes, my lords.
My lords. Here,
We will seek the presence.
please, my lords.
We'll take it to logical end. Let's be very clear.
My lords, here, my lords, she has not thrown her out, my lords.
She has sent them out, not thrown. Let's not use that word.
She was very much present and she was staying with the accused, my lords. Afterwards, my lords, voluntarily by taking
So you will,
all the things of
you will
the
allow them
accused-
to continue to reside in that house.
Let them reside, my lords. We don't have any
My
objection.
lords, my lords, 6,000, my
We don't
lords.
have any objection, my lords. I'm ready to take her back.
Payment of rent, my lord, the payment of maintenance of rupees 6,000.
Nobody is there to take care of this accused, my lords. Because of that, this honorable court has passed an interim order, my lords. My lords, may I make one submission? My lords, may I make
What
one-
was the order of the commission, this thing, tribunal?
My lords, is
Commissioner?
Annexure, my lords, annexure. Annexure D, my lords, page 32 is the translated copy. Operative portion is at page 39. There is also a direction to pay a maintenance of rupees 6,000, my lords, per month, every
So
month.
you were to stay in the back portion.
Yes,
I'm staying there only, my lords.
Very well, let them stay in the front portion.
Let them stay, my lords.
Go.
yes, my lords. My lords, I am ready. My lords, regarding maintenance, my lords, and also.
That 6,000 rupees?
Yes, my lords, she is also not paying that
They have
amount.
taken all
There
the
is no
property, my
stay.
lords. Behind the back of the accused, they have filed a suit for partition, my lords. They ended up in compromise and compromise decree also they have, and I will produce all those documents, my lords.
But there is a direction, ma'am, it has not been set aside.
No, ma'am.
It still stands. You have to implement it.
My lords, let them come and stay, my lords. We don't have.
He's not on stay. In any case, he's coming and staying there in the front portion. He's also concerned on the 6,000.
My lords, son is there, my lords.
We
And
don't
have
know.
preferred- My lords,
That's for you to work it out before deputy commissioner.
I have already filed the appeal, my lords.
There is no stay.
No.
You have to implement it. Until we say nothing, that order of stay would be prospective from that date till this amount for the past period has accrued. Getting? But we say nothing on that.
My lords, she's a poor lady, my lords. Nobody's there to take care of her, my lords.
You are in an
And
appeal.
2 children are there, my lords, minor children. And even husband is not taking care, my lords. It's a collusive suit, my lords. They have filed a collusive suit and they have obtained the decree, my lords.
The parents, the people.
In fact, they tried to pour a kerosene, my lords.
So you will tell us, take instruction, when are you implementing it?
My lords.
We can ask them to go and occupy the front portion. We'll record your statement. We are on 6,000, we'll defer it to that extent, take instructions.
Please, my lords.
The contempt has been filed alleging the violation of order dated 7th June 2023, passed by this court in writ petition 5836 of 22. And also which order continued in terms of order dated 3rd June 2024. Our attention has been drawn to page 39 of the paper book to contend that as per the orders of the Assistant Commissioner, the respondent herein was to pay a maintenance of rupees 6,000 per month.
Yes, my lords. From 8 to 2022, my lords. Order is
8th of February 2022.
22, my lords.
How do we get, where do
My
we
lords,
get
in
that?
page 40, my lords. Page 40. This order has been.
8 to 2022. And additionally, the respondent was to allow the appellants, the petitioner herein, the complainant herein, reside in the front portion of the house. So the submission of learned counsel for the complainant is none of the directions have been complied with. So the learned counsel for the respondent, on the other hand, states that the respondent has filed an appeal before the deputy commissioner.
Please, my lord, that is
We
still
concede
pending.
to the fact that there is no stay of the order of the assistant commissioner.
I make one submission, my lords. Here, what has happened, my lords, they came and stayed with the accused, my lords. So she was under the impression that, my lords,
In fact, she states that the complainant, along with her husband,
son, my lords,
who is the complainant
Hello.
along with the son,
please, my lords,
were residing in the front portion,
please, my lords.
were residing in the front portion of the house. And the respondent was under the impression the order has been complied with.
Please, my lords.
That's right.
Please, my lords.
But we find that there is no explanation for non-payment of the 6,000 rupees, 6,000 to the complainant.
My lords, relationship was very cordial, my lords. So we were under, I was under the impression that I need not pay that amount, my lords. Later, my lords, by
Stop.
taking all the orders
Frequently.
behind the back of this
Stop.
accused, my lords, they
She
have filed this
states
contempt.
that the complainant is within her rights to come and stay in the front portion of the house.
Please, my
We are
lords.
saying complainant. We are concerned with the complainant or the son also.
No, complainant.
Only complainant.
Only complainant.
Full stop. She also states she shall take instructions on the payment of rupees 6,000 to the complainant with effect from 8th of February 2022 on the next date of hearing. To take.
He has to take care of the two children, minor children. my
Maybe we are with you on that, but there is an order. Either you will take stay or you will implement it.
We'll take stay.
We will say nothing.
My lords, after 2 weeks, my lord.
Yeah, just give it in first week of July.
17,
Much of it.
17,
Complainant.
Shri Jagadish.
Accused word number 1 has not complied with the order of this order. In the sense-
Notice has to go. Who is appearing for A1?
Lord, my colleague Mr. Achappa is appearing for A1.
There's a wakalat filed, my lord, on behalf.
Mr. Achappa, in both the matters.
Wakalat has not been filed yet, it is awaited.
Pardon?
Wakalat has not been filed so far, it is
Okay.
awaited, and further instructions from the department is also awaited.
Okay.
I request
What do you want?
accommodation.
May I make one submission?
Make an objection. on everything.
The complainant who are working in the government tool training center.
What is the direction given?
Direction given is to enter for the benefit of retirement, because earlier the retirement age of the government employees was at 58 years. Now government enhanced the retirement age to 60 years. But this accused, despite the government order, without accepting government order, relieved the complainants. This matter was challenged.
What is your age today?
Today is now 72 years.
Oh.
Matter entered in the Supreme Court.
What is
They
the
have not
difficulty?
complied.
See, we will call the officer. Who is the officer?
My lord, sit.
The
Willfully they are
gentleman,
disobeying.
what had happened is 58 years they were retired, my lords. They got the benefit of 60 years.
That's right.
It was subject to the decision of the Honorable Supreme Court. SLP was dismissed in the year 2023, my lords. 8/11/2023.
So it was required to be implemented. Very much. So when, who has to implement?
The accused number one.
Accused number one.
Who is the person? Who is the accused number one?
KY Dinesh Kumar. He is the director or managing director of Government Tool Room and Training Center.
Very well. We'll let him be present in the court. We will proceed. Not like this. The gentleman ultimately retirement benefits. See what is happening. He has not got even the benefits for 58 years.
Yes.
You're getting the point? That's a normal retirement age. He has not even got that. Only because this 2 years was pending. The matter attained finality till Supreme Court.
Yes.
He is without pension. Just say this, learner counsel so and so appears for respondent number one, accused number one. States that what do you say? Tell us.
Lord, my instructions is because Mr. Achappa is not in station today. The counsel who is on record is not in station today. My instructions is that, my lord, he is yet to get the instructions from the accused number one.
Very well.
And he will file the necessary
Very well.
objections to that.
States that
And there is some copies that needs to be furnished is what.
we don't know what is the defense.
Please.
We
from
don't
the
see any defense. States that the counsel who has instructed you.
Mr. Achappa.
He has instructed you. What are your instructions by Mr. Achappa?
Lord, that they are awaiting instructions from the department. So that
Very well. We will take instruction from the officer. We will take instructions.
In
We
similar case,
find that Mr. Achappa is yet to take instructions from the accused number one. Appropriate shall be the accused number one shall be present in the court on the next date of hearing. Full stop. Just say first week of July.
There is already an order in a similar case.
The 3 orders.
Despite knowing same accused
Let
appear.
him come, let him
Yes,
come.
I will produce.
18, 19 is also
All the-
similar.
Say all are similar. No? All the three.
Which are the other matters?
18 and
18 and
19.
19.
Same, no?
Same matter.
Same submission in
Yes.
that also?
Yes, applicable to
Just take all, man. Presence.
3-7.
Let him be present.
Serial number 20.
Ma'am, 19 is also same.
Serial number 20,
18,
my lord,
19. Same.
it's a committee, my lord. Earlier, in the earlier round of litigation, it was represented by the government advocate, my lord.
You have to serve respondent number one.
My lord, there is no such committee, my lord. The committee for unauthorized occupancy.
We don't know, but you have made them a party.
No, correct, my lord. There is no such committee because the committee,
You delete it.
my lord, in the previous, may I make a submission? In the
When you array as respond number one, either you have to serve the copy or delete it.
my difficulty in
Why
my,
do you make a party who is not in existence?
no, my lord, my difficulty is, my lord, it's a committee
You are
that
not
is,
concerned with that.
See, you can't say both. This committee is not in existence, but I'll make
I will make a party.
party.
no, legally, my lord, that is a committee formed by the government to consider an application for
Who appears for
unauthorized.
2 and 3? Now, is there any committee by name?
I'll have
This-
to take instructions, my lord. If instructions is issued, my lord, we'll file the wakalat. We'll enter appearance. We'll enter
Because in the-
appearance, my lord.
Because in the earlier writ petitions, my lord, the committee was represented by the government. So therefore, my lord,
So he has solved your
yes,
problem.
yes, yes.
Just say that.
I'll take instructions, my lord.
Though notice to respondent number one is still answered, comma, the counsel appearing for respondent number 2 and 3 states that he shall take instructions about the existence of the committee.
Please, my lord.
Full stop. If the existence of the respondent number 1 committee, if such a committee is in existence, he shall take instruction whether to appear for the same
Please.
on the next date of hearing. Okay. List on, give it after the 4 weeks.
16-7. 21. Mr. Karnataka. 21.
My lordship, I am appearing for the petition.
Entries had to be restored, my lords. I have taken it up with the concern, my lords. Revenue entries had to be restored.
What do you say?
My lords, 3 weeks time I'll ensure that.
For what?
Whether we'll be filing the appeal or I'll see to that direction.
Then a counsel for the respondent seeks 3 weeks time to take instructions and file affidavit.
8-7. Serial number 22.
I'm appearing for the complainant, my lord.
Saying to the accused number 2, my lords. The order which they are seeking compliance of, my lords, it has been stayed by the
No, it's
coordinate bench of
not,
this honorable court.
my lord, it stayed only the order, my lord, 3. 3 means I have filed the application for leave and license to lease cum sale. That has been stayed, my lord. Petition has been allowed and there is a direction, my lord, extend the commission agent license, my lord, and also, my lord, they have to hand over the shop, my lord. They are
Your compliance affidavit. What are you
This is the
filing?
order of the coordinate bench, my lords, staying the.
Just show us.
Kindly, my lords, may kindly take page number 16, my lord. In that only order 3 has been stayed, my lord, because we have not made an application for a leave and license to convert in the leave and license to lease cum sale, my lord. This we have not made in the prayer, my lord, in the writ petition. Hence, this has been stayed, my lord, but petition has been allowed, my lord.
9.3 has been stayed.
9.3, my lord. My lord, may kindly
What is
take
the
the impugned
direction in
judgment, my
9.2?
lord.
What is the direction in 9.2?
9.3, my
and
lord.
2.
The petition is, may I read, my lord, page number 15, my lord. Order, my lord. Writ petition 1, my lord, writ petition is allowed. Second, my lord, the order dated 26/2/2021 passed by the second respondent at Annexure G and the endorsement dated 14/5/2020 issued by the third respondent Annexure E are hereby quashed, my lord. I am relying, I have filed the contempt petition, I am relying and seeking this, my lord, the forfeited. They have issued the endorsement and forfeited my shop, my lord. They have not till today. The petition is allowed. They are not handed over to me, my lord. That's why I have filed the contempt petition, my lord. The 3 is, my lord, the petition is granted liberty to file an application strictly in terms of the sub rule 2 of rule 12 of 2 of the rules 2004 within 4 weeks from the date of received certified copy of this order. If such an application is submitted, the third respondent is directed to consider the application strictly in terms of the rule 12 class 2 of the rules 2004 and pass an appropriate order in accordance with law, my lord. I am not seeking this, my lord. Let them not convert my leave and license to lease cum sale, my lord. But the endorsement issued by them has been set aside, my lord. They have to hand it over the possession to me, my lord. My shop has been allotted to me, my lord, for the 55 months, my lord. I have not even completed 2 years, my lord. That has been forfeited by them, my lord, because I have not paid the amount, my lord. In this writ petition is pending, my lord. I have paid the entire amount, my lord. Then they granted interim order also. That time also I requested many time to hand over the possession. Let me continue my business, my lord. They have not handed over. Then the writ petition has been allowed, my lord. Till now my shop is with them, my lord.
My lords, there's no express in the operative portion. There's no express order that it has to be re-allotted to them, my lords. Only para number 3.
3, 5 and C5. What about 9.5?
Please, my lords.
Nine five is revived.
Please, my lords.
What is the effect of revival?
Action up to the validity. Lords, I'll just take instructions, my lords.
You can't do anything.
Please, my lords.
It's only granted liberty to file application strictly. That's application need to be, that has been stayed.
Please, my lords.
Rest nothing has been touched.
That's a week's time will be granted, my lords. I'll just take instructions.
So just say that though we have been informed that in an appeal filed by the respondent herein, that is the Agriculture Produce Market Committee, being writ appeal number, the writ appeal number being WA 1090 of 2024. The division bench has stayed the operation of the direction of paragraph 9.3 of the impugned order during the pendency of the appeal, comma, as being urged by the learned counsel for the petitioner, comma, merely because the paragraph 9.3 has been stayed, the respondent cannot deny the implementation of the other directions given in the order of which contempt is alleged, comma, the learned counsel for the respondent seeks some time to take instructions.
Grateful, my lords.
Date may be fixed, my lord.
We give it out of
7. Serial number 23. 23.
My lords, vide the proceedings dated 21/2/2025, the state has decided to prefer the SLP, my lords. As of now, the filing has not been done. We'll expedite and file the SLP and give the diary number within 2 weeks' time, my lords.
I am the proxy counsel, my lord. Pray for some time.
Pardon?
I am the proxy counsel.
Yeah.
Prays for 2 weeks time.
Just say that the Lena Council, though a adjournment is sought on behalf of the counsel for the petitioner, we take on record the submission made by the Lena Council for the respondent, that the respondent intends to file a SLP before the Supreme Court within 2 weeks. He undertakes to the court that the filing number of the SLP shall be submitted on the next date of hearing.
Very much, my lord.
17/7. 24.
Complainant. But direction is, my lord, by the division bench of this honorable court, the state government, to consider the case of the petitioner to the post of assistant lecturer bar instructor as per the special rules, my lord. Page number 17, my lord, is the order of this honorable court, division bench of this honorable court.
Intimated that on 7th of December 2024, we have considered the representation. I'll file the necessary complaints.
What happened in that consideration?
My lord, in the
Consideration, we have rejected the claim of the complainant.
Lord,
It's a reasoned order. We'll
the
file a
reason
translated
assigned,
copy of
my lord, I have received the endorsement. The reason assigned in the said endorsement is that, my lord, as per the special rules, my lord, there is no provision for absorption to the post of instructor. That stand was taken before the tribunal itself, my lord. This honorable court,
You reiterated the same ground.
same ground they have reiterated, my lord. Kindly, my lord, I produced the statement of objection filed before the KIT, my lord.
No, where is the endorsement? Have you received any
Yes, ma'am.
endorsement?
Yes, ma'am.
Where was the endorsement?
Therefore, my lord, I have filed additional
Let's see
document.
that. Let's see that.
Please, my lord. Last paragraph.
Reiterated procedure.
Last paragraph.
I have the translated copy for the benefit of the court, my lords.
Yes, ma'am. Where is that?
You have got the translated copy for the benefit of the court, if my lordship is here to permit.
So what was your ground before the tribunal?
My lord, I have filed the reply statement filed by the state government along with the IA 1 for 25, my lord. Page number, my lord, page number 19 along with the IA, my lord. The specific ground taken by the government is that, my lord, as per the special rules, there is no provision, page number 19, my lord, along with the IA, produced for production of additional documents, my lord. Page number 19, my lordship. Paragraph 11. In the prayer column, the applicant seeks a direction to the authorities to observe her as assistant lecturer bar instructor. In the state civil services, it is already made clear that the applicant is not entitled to observe as a lecturer. She is not entitled to be appointed as instructor for the simple reason that there is no provision for absorption in the cadre of instructor in the absorption rule. This is a stand they have taken by before the tribunal, my lord. My lord, this honorable court, division bench of this honorable court, my lord, after hearing the matter, my lord, directed the respondent to file an affidavit, whether based on the diploma qualification, whether instructor has been appointed on the basis of the very rules or not. Kindly see, my lord, annexure B, my lord, along with the contempt petition, my lord, page number 19. This is the affidavit filed by the state government before this honorable court. Page number 19, my lord, annexure B. From paragraph 2, my lord. I respectfully submit that the honorable court by order dated 18/6/21 had directed me to file an affidavit as to whether those persons who are holding diploma only have been regularized or not. It is submitted that part-time assistant lecturers with diploma qualification were regularized as assistant lecturer and instructor and not as lecturers. Whether the persons who are holding diploma initially and later on obtained degree have been regularized or not. It is submitted that as per records, no such cases were found in the absorption order. I respectfully submit that as per the Karnataka State Civil Services rules, absorption of persons working as part-time lecturers and part-time assistant lecturers in the Karnataka Education Department Services, Department of Technical Education, Special Rules 2004, and Government Notification number so-and-so, 14 to 25, provisions were made to observe the services of the part-time lecturers and part-time assistant lecturers to the posts, equivalent to their educational qualification, who are working in the government polytechnics coming under the purview of Department of Technical Education, who at the time of their initial appointment fulfill the educational qualification, service condition prescribed by the AICTE, and cadre and recruitment rules of the Department of Technical Education. And also, we have worked for 2 academic years, 1993-94 and 94-95 as on part-time basis. Accordingly, the government issued the following absorption order. In this malad, item number 2 malad, government notification number, say, item number 2 at annexure 1. Part-time lecturers with degree qualification who have worked for 2 academic years, 93-94 and 94-95 on part-time basis were observed to the posts of lecturers as per then existing cadre and recruitment rules 1987. At annexure 2, this is important, malad. Out of 6 part-time assistant lecturers with diploma qualification who have worked for 2 academic years, 93-94 and 94-95 on part-time basis, 1 part-time assistant lecturer, namely Srimati Vanamala, Commercial Practice Department, observed to the post of assistant lecturer in the commercial practice. Since the other 5 part-time assistant lecturers in engineering departments were not possessed the educational qualification prescribed as per then existing cadre and recruitment rules 1987, they were observed to the post of instructors as per the diploma qualifications. Wherefore, I respectfully pray that this honorable court may be pleased to take note of the above said facts and pass appropriate orders.
What does the division bench say?
Division bench, my lord, since the petitioner possessed the requisite qualification to the post of instructor, therefore observed or to the post of instructor, my lord. Page number, my lord, 18, direction of the honorable court, my lord.
Page number 18,
18,
Roman 5 may be kindly looked into.
Prayer, my lord, 5. The respondent state shall consider the case of the petitioner for absorption as assistant lecturer or instructor in terms of the special absorption rules in accordance with law within 3 months from the date of receipt of copy of this order.
Now, whether assistant lecturer can be absorbed?
Yes, my lord. Based on the special rules, my lord, they have observed.
But does the rule contemplate absorption as
Yes.
special instructor?
Yes, my lord.
Or instructor? No, special lecturer or instructor?
My lord, lecturer and assistant lecturer. In the department of my lord, costume design, my lord, there is no post of assistant lecturer. The assistant lecturer and instructor is one and the same. The education qualification is one and the same.
Okay.
The pay scale is one and the same.
The
There-
nomenclature is different.
Yes, my lord. Therefore, the state government, based on the very same rules, observed 5 instructors, my lord, assistant part-time lecturers as instructor. They have filed the affidavit to that effect. And my lord, they have
What are your
You're given the reasoning at the last 4 paragraphs of the endorsement.
Where is the endorsement?
Endorsement translated copy just now, I have just
shows
passed
this
it over,
one.
my lord.
this reason, my lord, they have taken.
Just 1 minute. Where is which paragraph?
My lord, the second page of the translated copy as such. my lord.
Yes.
The last but 3 paragraph, my lords.
Read it.
While government notification number such and such dated 24/6/2008, 8 part-time lecturers, including you, were regularized in the government service. However, in the subsequent development, after re-examination, it was found that the conditions of the absorption rules were not fulfilled except Shri Prashant BP, English lecturer, Karnataka Government Polytechnic, Mangalore. The service regularization order dated 24/8/2006 of the remaining 7 part-time lecturers, including you, has been cancelled with retrospective effect by government notification such and such dated 9/2/2009. So the parity does not continue because we have sort of suspended the earlier order which gave them the benefit as such matters. We are further told, accordingly as per the cadre and recruitment rules and the Department of Technical Education 1986, since you do not possess the educational qualification prescribed for the post of lecturer of the Department of Costume Design and Dressmaking at the time of your appointment as part-time lecturer, as per the rules, there is no provision to
But
regularize.
she doesn't want lecturer.
No, no.
She says instructor.
My lord, sir, this endorsement translated copy, I got it in the morning. I'll get instructions whether we are able to justify.
So what is the submission is assistant lecturer and instructor are equivalent posts. Identical or same, its own nomenclature only different. It is not his case for lecturer. And even the direction appears to be absorption as assistant lecturer / instructor. So what your stand is, it appears to be for the post of lecturer.
My lord.
She doesn't fulfill. It can be a fact.
We are at the third para, the last para, we have dealt with the other part also as such.
As per cadre recruitment rules, where you have the education conflict prescribed for the post of instructor, but the Karnataka Education Services Department rules do not allow to absorb the post of instructor. Now, which rule
My lord.
contemplates absorption? Tell us one rule. See, there is a direct recruitment component? There is. You have to fill it as a direct recruit against direct recruitment.
I'll point out the special absorption rules which is applicable in the present case as such.
You know, what does those rules contemplate?
I'll bring it to the notice of the court by means of a
See,
detailed.
no
affidavit.
rules will contemplate absorption. It will contemplate direct recruitment, promotion or deputation.
My lord, these rules, my lord, were framed as a one-time measure for the yes, my lord. In the year 2005, as a one-time measure, my lord, absorption of part-time lecturers. As a one-time measure, my lord, state government has framed the rules for the absorption of part-time lecturers as well as the assistant lecturers, my lord. As per the said rule, my lord, I was observed. My lord, later on, it was recalled on the ground that it does not possess the requisite qualification as on the date of appointment to the post of lecturer. But my claim before the tribunal is that, my lord, as on the date of my appointment, part-time appointment, I possess the requisite qualification to the post of assistant lecturer or instructor. Therefore, my lord, I sought for the appointment to the said post. State government has also observed 6 instructor.
Instructor without there being an absorption clause.
No, yes.
No,
That is the affidavit they have filed before the honorable court.
This is what he says.
Affidavit they have filed, my lord.
For instructor also there was no absorption according to you, but still people were absorbed.
I'll see if the parity exists or have we sort of cancelled those absorptions also.
No, my lord, they have not
I'll file
cancelled.
a detailed affidavit to that effect.
Lord, the state government has utilized my service for 20 long years, my lord.
For one person, you will take away absorption of 6 or 7 persons. That's what your submission is.
Not my submissions as such, my lord. If
and there will
already
be
it's
6
been
more.
taken away, I'll point it to the notice of the honorable court as such.
And mind it, when others have been given the benefit,
My lord.
this stand, it doesn't contemplate absorption, cannot survive, cannot hold good.
And now the petitioner, my lord, is 57 years old, my lord. In the year from the year 2009, my lord.
You working today?
No, my lord, for 20 years I worked, my lord. After filing application, my lord, they have removed me from service, my lord. From 1993.
Now this absorption would relate back to which period?
No, my lord, the direction is, my lord, prospective effect, my lord.
Now what will happen? That means you will be absorbed and then taken on roles.
Yes, my lord.
What will happen in the interregnum?
Interregnum, my lord, there is no.
Termination till absorption.
There is no such benefit was extended in the rules, my lord.
Very well.
Therefore, my lord, state government is protracting the proceedings to see that, my lord, the petitioner shall attain the major superannuation without observing, my lord. Now she is at 57.
2 weeks time.
That we will see it. Today he had 2 judgments in his favor. One court below and the division bench. That we will see it. But in any case, you must take instructions on
Very much.
The learner counsel for the respondents would submit that the order of which contempt is alleged has been implemented. He states that an endorsement dated 7/12/2024
Very much, my lord.
has been passed, whereby the case of the petitioner has been rejected. Petitioner for absorption to the post of instructor has been rejected as the special rules of 2004 do not allow absorption on the said post. This submission. Qualification for lecturer. Though he has education qualification. You have education qualification, but rules doesn't contemplate absorption. For instance, absorption to the post of instructor, or this submission of the learner counsel for the respondent is contested by the counsel for the petitioner states that despite the rules position, comma, the respondents have absorbed 7 instructors.
Five, my lord.
Five instructors. In which year?
Not in the year 19, my lord, 2006, my lord. 4/9/2006.
4/9/2006. 2006. That is after the formulation of the special rules in the year 2004. The learner counsel for the respondent seeks time to take instructions. At his request, how much time?
2 weeks time.
2 weeks. After 2 weeks.
2/7.
Not the short document. 2/7 is the long, my lord.
So give it after 2 weeks.
18/6.
Oblige.
Next.
Serial number 25. Devraj. 25.
I appear for the appellant. In this case, my lord, appear for praxi counsel for respondent number 1 to 6, my lord. He is not feeling well, my lord. Kindly take up 2 weeks time for filing the
At
objection.
the request of counsel for the respondent adjourned to
21/7. Serial number 26.
Appear for the appellants, my lord. The office note says the respondent has not claimed the notice, my lord.
unclaimed by the advocate.
Steps to be taken in respect of the
Unclaimed. What is this? By whom? We have to issue fresh notice. The report. Is it deemed service? It's not refusal. Do- Door locked. But this report is different. Both are different. You see, this is 24, this is 29. Can we take it? The report of service on the respondent states unclaimed. Full stop. Shall we say effective? In view of the report, comma, the service on the respondents is deemed to have been effected. Full stop. We find there is no appearance for the respondent. List the appeal for hearing on.
21/7.
public.
27.
State appeal is also there, my lord. Section 128A of the Cooperative Society has been struck down. Matter requires to be heard, it will take some time.
It will be argued, no?
Please, only request is, my lord.
Two applications are there. It is connected with item number 27.1. One application was 65 days delay is there, I sought for conservation of the delay. Second, appears to-
You have sought for
condemnation of
65 days delay. Then
Then my lord, before the record, I assisted the court as an interviewer with the leave of the court there. Here, my lord, I filed an independent appeal. I seeking you to file an appeal.
see it. Although there was no substantive claim by you, you were only assisting the court.
Very rarely I am supporting the state.
Very well. Now, who are these 4 to 7 who have to be served? 4 to 7.
I think
Petitioners, my lord. They are the petitioners in repetition, my lord.
So you appear for them?
I'm appearing for respondent number 4, my lord.
Who's appearing for
What about
petition?
5, 6, 7? See, then you have to serve 5, 6, 7. We can record his
Counsel.
he appears.
Mr.
Then
Keshav Bhatt
Mr.
appears.
Jagdish Rao.
No, in the connected matter is already there.
Oh, they are there?
Is Mr. Keshav Bhatt's name is already there. is already there, my lord. So therefore, he can take notice.
No, Mr. Bhatt only appears for one, Mr. Shetty. Keshav Bhatt, Mr. Keshav Bhatt appears 2 to 4, Sanjeevani P. Nawadgi.
My lords, I appear for respondent number 6, my lords.
They are the intervening applicant.
But tell us one thing, who appears for 5, 6, 7 in the first appeal? Anyone appears, we record it. And who appears this 2, just show the other appeal.
Interim yaar idhar hai?
2 is 2, 3, 4, yeah.
My lord, bike. Please, my lord, he was.
Hello, ಆಗಿದೆ ನನ್ನ ಅದೇ R6 ನಾನು
Take instructions, my lord, and file wakalat, my lord. Let them pay process, my lord. In meantime,
This is only to drag on the proceeding.
No. In meantime, I'll.
Lordship, to solve the problem, my lord, let hands of summons be taken on the petitioners as well as the council, my lord, so that it will
But
not
we
drag
find,
on.
Mr. Shetty, we find this respondent 2 to 4 in the second appeal
Please.
are Jagdish Rao, Mr. Yashwanta and Gopal Krishna Bhatt.
Please,
These are the same 5, 6, 7. No, but here it appears to be, oh, Keshav, Mr. Keshav Bhatt.
Please, my lord. Yeah, that your lordship will get it at page number, my lord.
So we will say Mr. Keshav Bhatt.
Please, my lord.
They say that though the office reports suggest the respondent 4 to 7 in writ appeal 1722/2024 have not been served, we find that Mr. Keshav Bhatt, advocate, has filed wakalat for respondent number 2 to 4. 2 to 4. 4 to 7. No, 2 to 4 in the connected appeal, that is WA 1484 of 2024. Full stop. Hence, we take it that Mr. Bhatt shall appear for the respondents 5 to 7 as so and so appears for respondent number 4. Okay?
My lord, I represent respondent number 9. I have filed wakalat now, my lord. Name is not shown, my lord.
In which appeal?
Which appeal?
Writ appeal number this number. The first one or the second one?
First one.
Full stop.
Case number.
Respondent number 9, sir.
Case number, ready, sir.
Straight. Second appeal.
1484.
The name of the council, just take the name of the council, be shown in the cause list for respondent number 9. For respondent number 9 in WA 1484 of 2024. This is Belgaum District Central.
Yes, madam. Yes.
Belgaum Central Cooperative Bank.
Yes.
That's what for. Okay. List these appeals for hearing on. Just give it in July or August. Anyone have any objection, Mr.
No, madam.
They just take IA 1 of 24. This is an application seeking 65 days delay in filing the appeal for the reasons stated in the affidavit accompanying the application. And the learner counsel for the parties have no other, the opposite parties have no objection. The delay of 53 days in filing the 65 days in filing the appeal is condoned, application disposed of. Leave, we will keep it, Mr. Rajgopal.
Can I request?
Leave, it need to be looked into.
Can I request third week of June, my lord, if
Not
possible?
possible, Mr. Shetty. We'll have it in July.
Any date, maybe, if possible.
We're fixing a date.
70. You file your submissions.
We'll do
Counsel for
that.
the parties to file the written submissions along with the judgments they intend to rely upon at least 1 week before the next date of hearing.
We'll do that.
Let those application be there. You are only an intervener. You want to assist. One can hear. One intervention was allowed also. it's a more question of law, I suppose.
Effectively assisted, but the order was set, the 128 was set aside. And all the lighter side,
He's so convinced about his stand, he's in appeal now.
He will appeal. That is what.
Next.
16-7. 28, serial number 28.
I appear for the petitioner, my lords. My lords, the matter, my lords, lies in a very, very short compass, my lords. My lords, I have filed, my lords, for a
Meeting is today 1:30. This is regarding constitution of CSB.
Constitution of the Civil Services Board.
Oh.
The direction of Subramaniam, my lords, is TSR Subramaniam in the year
I'm
30.
going for the meeting. It is for the law minister.
When do you want?
After 3 or 4 weeks. We'll take it.
My lords, today,
What is the, no, if the board is constituted, what follows?
then the transfers and everything is regulated by the board.
Oh.
Now, my lords,
This is for the All India Service Officers?
yes, my lords, the anxiety, my lords, that I had shown to the, my lords, your lordships may kindly have a look at the.
1:15 today. It was at 12:30. It was at 12:30.
Yes,
Well, I'm not-
1 minute, Mr. Shetty.
I'm not, my lords. It can be had. They can have their meeting. Let them report what happens next week, my lords. There's a difficulty that I had expressed, my lords, which is recorded in the earlier order sheet. My lords, for 12 years, transfers have taken place without this. My lords, therefore, I had requested, my lords, could it be constituted before this transfer season? There's a season in Karnataka. Now, my lords, the reason why it is postponed, my lords, if it's held after 4 weeks, then 1 more year of transfers, my lords, will take place without CSB. Therefore, my lords, the courts had given, my lords, a shorter date and said, my lords, in fact, on the last date, they had said, please, positively. They had said, my lords, meeting is conducted again on a particular date. Nothing has come forward. Anyway, my lords, learned advocate general is saying, I have no difficulty. Could it be had next week so that they can report what took place? That's all
Yes,
that.
definitely we need some time, Manoj. Any reasonable period, I mean, any.
Just say
They
that,
just have to report what happened today. Could it be had next week? That's all. that happened.
Not,
Just say Mr. Shashikiran Shetty, learned advocate general, states that the meeting of whose meeting?
comprising law minister and home minister and.
The meeting in the state government is for Constitution of Civil Service Board is fixed today at 1:30 PM. He seeks a deferment of the matter to enable him to place before this court the decision taken therein. At his request, when do you want? First week of July?
Second week of July, Manoj. Can
Why?
Manoj, it takes some time, Manoj, because your lordship, we can have it by second week of July, we'll come back with some.
I'm requesting for next week.
Manoj,
Your
if my
lordship,
lordship is
work out-
12 years, nothing.
Second week of July.
Grateful to.
But you must file an affidavit.
We'll file
See,
one.
his apprehension is without the board being in place, the transfer would be affected.
Well, that doesn't matter. 12 years, the only question is, Manoj, transfers have been happening without the board.
His concern, na?
So therefore, we have examined all the states act, Manoj, which and all out of number of states which are there. Half the states do not have that, but we are trying to incorporate what are the clauses in that so that we come up with a comprehensive, so that tomorrow it is not challenged and it is done strictly in terms of Supreme Court judgment, Manoj. Because,
The apprehension.
Manoj, apprehension is, Manoj,
The board you are doing.
it's been going, Manoj, it will be finally done for all for in future, Manoj. Let us not worry about what is happening in next 4 weeks or 6 weeks, Manoj.
Let me make this suggestion. Your lordships may have it after 4 or 6 weeks. Till then, let them not.
That is
affect
the
transfer.
question does not
After
arise.
the constitution of the board, anyway, they are taking a decision.
Day-to-day administration cannot be stopped at one person's.
It's only
Let's
transfer.
see it, Mr. He's saying so, we'll have it in second week, just early second week of July.
Your lordships may
Earlier
have a
part.
look at the order sheet, my lord. Just the look at the order sheet.
But one thing is, Mr. Shetty, I think this
No, in
decision
fact, the
will be
meeting-
taken at the earliest.
We'll do it at the earliest, Manoj. In fact, what your lordship fell from your lordship, I'll place it before the meeting today at 1:30.
See,
also.
something is contemplated by the directions of the Supreme
I'll
Court
go
must
down
be
to,
in place.
that is what I'm, absolutely, Manoj, that is.
Next.
7-7.
Second week, Manoj, for early, at least.
Seventh?
Seventh.
You said second week, Mr. Shetty.
Can I have it at least? I'll leave it to your lordship. I would not want to.
I hope we have heard you right. You said second week of July, not August or October.
No, July. At
So we
least
have given you July. Next.
Grateful to Manoj.
29. 29.
My lord, appearing for the petitioners in serial numbers 29 and 30. My lords, appearing for the petitioners in serial number 29 and 30. It's a mining matter. I am a quarrying leaseholder in survey number 23 in Attiguppe. Both the 29 is about 4 acres in serial number 30.
Have it re-notify. We'll have it some other day. Not
My lords, yes, my lords. Only request is on the last occasion it was posted for their statement of objections. This petition
Ma'am,
came
you
to
have
be
filed your objections?
5 months, my lords. 5 months time has been given.
You must file your. But you should file your objections, na? When do you file? When will you file?
My lord, on the day we may be heard on interim relief, my lords.
Pardon?
Only request. On the day of filing their objections,
Yeah.
we may be heard on our interim
The
relief. 5
counsel,
months will not be heard.
the learned counsel for the respondent states that the objection shall be positively filed within 3 weeks from today. The submission is taken on record. Re-notify. Yeah, 2 weeks for rejoinder.
Please, my lords.
14/7.
Next. 30 is also same?
30 is also same.
31, Srimati Rajeshwari.
Appeal for the complainant Milord case. This is regarding non-compliance of the order passed by the first. Please.
4 weeks time, my lords. Contempt of the year 2025. So the vacation also ensured 4 weeks. You come back with the
At the
affidavit.
request of counsel for the respondent, saying for compliance,
I shall file the necessary affidavit.
to file an compliance affidavit
Very much.
within 4 weeks adjourned to.
32 also.
9/7.
This is 32.
This is 31, my lord.
This is 31. You say 30?
The next matter also, we require
Who
this.
appears for that?
32 appear.
Same order.
Three
4
months
weeks,
time
my
has
lord,
been
4 weeks.
granted by the learned single judge to comply it. 3 months is over.
See, this taking time, I don't
My lords,
understand.
2025 contempts, my lords. We have issued the notice. We had the
This-
vacation in the middle, my lords.
Will that
Beyond 4 weeks, we will ensure that the compliance. is
Already
affected.
respondent number 1 has
That's no reason.
We won't repeat such reasons, my lords. 4 weeks lastly.
Government is working.
Very much, my lord.
It's for you vacation.
Very much.
4 weeks.
Government also goes for vacation.
For us to remind them, there's an interregnum of 4 weeks which has not happened.
Okay. 4 weeks as a last opportunity.
Very much, my lord.
Why there should be a reminder by you?
It's happening that way, my
And
lord.
what that, all that order, etc. is there, it automatically flows to them through the system.
already respondent 1 had
That's
issued.
implemented, my lords. That's implemented.
Respondent number 1 had issued
Not
notice and
for it is
proceedings were held.
Unless
We have represented.
See, to me, there cannot be any reason for not to comply.
Very much.
Unless and until you have gone in appeal and there is a stay. That's the only reason. Otherwise, there can't be any defense.
You may have gone on vacation, but the government has not gone on
Very much.
vacation.
The replies are being delayed, compliances are not being made. Yes, next.
9/7. 33, Shri Murugesh Charity.
Lord, we have filed the memo along with the documents, my lord. Registry has raised some objections, my lord. We will clarify and come along with the
Next week,
translate
Rajasthan,
copies.
At the request of counsel for the appellant adjourned to,
Kindly out next week, my lord, we will come along.
we'll have it in July.
17/7. 34. 34.
Notices, we have, notice has come, government advocate.
This issue is settled. SC/ST. What do you want?
Government advocate can, he can accept notice, authorities.
No, just we will hear this. See, the issue is now settled.
No, man.
This is also, yeah. Who appears for respondent number 6? You appear for 1 to 6? Awaiting service. Yeah, man. Issue notice to respond, let fresh notice be issued to respondent. But you are 1 to 6, Deputy Commissioner. I'm sure the file, man. Let notice be issued. You appear for 1, 2, 3. So and so appears for 1, 2, 3. Let notice be issued to respondents 4 to 6. Returnable on.
Interim arrested. Interim arrested.
Interim order, if any, to continue till the next date of hearing.
17/7. 35.
Working the provisions of PTC. Yes.
For the respondent, my lord, 31 to 33, my lord, may I seek for some time, please? My lord? 31 to 33 and
Not possible. We'll have it some other day. At the request of counsel for the respondent number
31 to 33, 35 to 38.
31 to 33 and 35 to 38 adjourned to.
15/7.
Please.
Next.
36.
Pardon? 12. Just give it 12.
12/7 holiday, sir.
Huh?
12/7 is holiday.
12/7 is a holiday. Give it 13. 13th. 13th. Huh? 13th. Oh, just tell him. Just call him. 13th. Even 13th is a holiday. We'll give a working day.
14/7.
14th, please. Much
Sir, July, sir, 6. June, alla, sir, July.
July.
July any date, my lord.
Next.
14/7. 36.
Yes,
36.
Mr. Rajgopal. 36. What is the 36? Who appears in 36? What is it? Non-furnishing. Who appears for accused number 3 and 4?
36, we have positively complied with the directions, my lord.
Who is the other side? You are aware of it?
My lord, out of the portion of the order has been complied. Only reinitiated, my lord, with respect to the arrears, continuity of service and all other consequential benefits not given, my lord.
We have reinstated the consequential benefits also will flow, my lord.
No, my lord, not as.
So to say that positively you have implemented doesn't hold good. Just
Partially complied.
You must file your affidavit. Otherwise,
Filing the compliance, my lord, further compliance.
no, we
also.
will not take this compliance. We want a full compliance. And we will say so the officer would be present now.
My lords, we have reinstated the.
But that's not the direction. What are the direction? What is the use of reinstatement without any consequential?
Reinstatement, and he has also reported to the duty as such, my lords.
See, there is a consequence of reinstatement also. What is that consequence?
That the benefits is to accrue to it.
Continuity of service, all consequential.
Though we have been informed that the appellant, the complainant has been reinstated in service, the other benefits, other consequential benefits have not been paid. Compliance affidavit shall be filed within 4 weeks. If there is no compliance, the officer shall be present in the court on the next date of hearing. Who is the officer?
Director of Municipal Administration. My lords, I'll ensure that let there not be a precipitative order as such. I'll ensure that the
1
compliance
minute,
is done.
please. It's a conditional order.
Very much.
If it is not implemented, then he will be present.
That's
right.
my lordship.
Ensure it compliance.
Please.
If the order is not implemented, the director,
Municipal administration.
municipal administration shall be present in the court on the next date of hearing.
God bless you.
7.
Next.
37.
37, 38, 39 and 42 arising out of the common order of the learned single judge. Office objection is that they asked to file it firstly. Copy is ready to be able to place it on record.
We will have it some other day, Mr.
Any day that this month.
You are appearing in person?
Yes, my lord, 14%.
Now, what is the issue?
My seeking my information related my service, my lord.
Okay. This was under the RTI Act.
Yes, my lord.
Just say that re-notify these appeals on, give it in July 2nd week.
Could it be the last week or third week of June? Only for preliminary hearing.
We'll see it.
Short question is involved. And it's according to what is covered by the collector's judgment of the offense.
But what is your objection? What was your defense?
Defense is not a trustee is not aided. And even aid is also not full. It is only a partial. Para 48 of the Supreme Court in collector's case, even in some financial consideration is extended by the state, it would not attract not public.
Are you saying public authority?
Yes, it is not a public authority, which is the meaning of.
We will see. We will see.
My lord, 2012, my colleague is giving a RT by falling under public authority. In 2012, is
They have,
decided in
they have given the
same
information.
institution.
Okay. 38
My
to
one, my lord, one request, my lord. Not producing the registration copy for trust. Office objection is there, my lord. That's very 1963. Now from 1963 till today, the trust is not registered.
So you have asked that information?
No, that is the Honorable High Court is produced as a objection.
Oh.
That is important, my lord. That is important.
Whether institution and trust could be taken as an integral part or independent.
But you have to produce the register.
Custody, we will place it on record.
Just say that,
My-
Mr.
Place it on record in the registry.
Mr. Rajgopal and a
Is
senior
a
counsel
public
for
charity,
the.
my lord.
Yes.
District court is a guardian, my lord. District court is a guardian of the institution, my lord. District court is a guardian of the institution. From every trustee is appointed by district court, but not appointed. From 1876 started the institution up to 1926 guardian of the district court. Every trustee is appointed by district court for 2 years lifetime. After 1926 joined the government of Maharaja, and then after independence 1963 trustees are appealed to the government. Trustees are back to the institution, but trustees are not appointed by district court, are not appointed by any government. Is one family.
See that.
It's very important, my lord.
We'll see that. Mr. Rajgopal and a senior counsel for the appellant submits that the registration, the objection with regard to filing of the registration certificate shall be complied before the next date of hearing.
14/7.
ಅಲ್ಲ ಏನ್ ಬೇಕು ಅಂತ ಕೇಳ್ತೀನಿ. ಟ್ರಸ್ಟ್ ಡೀಡ್ ಬೇಕು. ಟ್ರಸ್ಟ್ ಡೀಡ್ ಬೇಕು ಅಂತ ಕೇಳ್ತೀನಿ. Some scheme suit, it was composed. That scheme suit judgment, what the required information asking by the court, we will provide within 1 week.
No, what he has sought.
He is not he sought for. It's an objection by the registry. They are asking us to place this trust deed on record.
That's.
Yes, that we will, what required information to be provided, we will provide it to the registry.
Yes, that's right. The registry has asked for registration certificate.
Yes,
of the.
it
That's
is a
only.
trust matter, question of registration certificate would not arise. Trust deed will be registered. It contains a certificate also.
Okay, you produce it.
Yes, that we will place it on record.
We have noted that registration certificate shall be produced along with the trust deed.
Yes,
There is
trust deed, at the end, it have a certificate of registration. That is the certificate of registration.
Produce it.
Yes, we will produce, no bargain.
This regarding the PU board giving a notice, 1960 today not register the management.
They say they have a registration. Let them file that.
But he
my
sought
file-
for
file them.
information.
No,
He
not
has nothing to do with this.
My lord, it's not fall information.
1 minute, please.
Everything is there, my lord.
You
Everything
give him
is
a
there.
copy, Mr. Raj.
We will, my
I
lord.
submit it. My
After
list-
providing a copy, we will file
Document
it
is
on
there.
record.
Everything document.
Let him file it. He will give you a copy, then make your submissions.
Okay, man.
40.
Seal number
37, 38, 39 and 42.
Okay. 37, 38, 39 and 42. Okay.
Yes.
Seal number 40. And the
40
complaint.
is over, ma'am. I thought 40 is different.
I'm undertaken to file the wakalat on behalf of
On
the
the complaint
accused,
in
my
case,
lord. Just now informed by the
You
authority.
appear for 1 and 2.
I undertake to file the wakalat, 1 and 2, my lord.
No, for whom?
Accused 1 and 2, my lord.
So and so appears
Vishnuvardhana
for
and Krupalini.
though service on A1 and A2 is incomplete, comma, so and so appears states that she shall file wakalat on
Patient
their
charity.
behalf. On their behalf
Within 1.
within 2 weeks. List on. Forty-one.
10/7.
Wait,
41.
on the complaint in case.
41.
For the
The
accused in the
complaint in
back.
case.
Compliance. The order complied?
I'm the complainant in this case.
Yes.
I'm for the accused in this matter, my lords. I have filed wakalat for the first accused already. My lords, I'll take notice for the second accused as well. My lords, I'm instructed, my lords, that the order has been complied with. My lords, may permit me to file a memo to that effect, my lords.
Give him a copy.
Please.
What was the direction?
To consider the representation of the complainant here, my lords.
You have considered?
We have considered, my lords. It's been rejected. Lords, may
Time may
permit-
be granted, my lord.
For what? You have to challenge that order. Challenge that order, rejected.
My
Been
land,
rejected.
my land has been utilized for the accused authority, my lord. And
Right, but you have to challenge that order. That's right. So he'll withdraw this and file a substantive petition. The learned counsel, Mr. Ajay Kumar.
Ajay Kumar.
Mr. Ajay Kumar, who has filed wakalat for A1, states that he shall also appear for A2.
Please.
He has also filed a memo stating that the order of which non-compliance is alleged has been complied with. He has, a copy thereof has been given to the counsel for the appellant, complainant,
I must apologize, my lords. I couldn't secure translations in time.
who states that he shall withdraw the contempt petition and challenge the endorsement dated 31/5/25 in accordance with law. That's right?
please, ma'am.
Dismiss as withdrawn.
Please. Great.
43, government advocate.
Serial number 43, my lord, this is same as serial number 27, my lord, where there is a challenge to the provisions of section 128E of the Cooperative Societies Act, my lord. Lordship has posted that matter on 16/7, serial number 27, my lord, writ appeal 1722 of
Just say
24,
re-notify on 16/7.
along with writ appeal 1722 of
This
24.
arises from the same impugned order.
Please, my lord, it's a common order, my lord. Challenge is the same, provisions of section
But are
128A.
these respondents represented in those?
Yes, my
matters?
lord, this is the matter in which the Advocate General appeared.
No, but the respondent herein,
Respondent herein, the notice is awaited, my lord, respondent number 1 to 4. They have already appeared in the connected matters, my lord.
but would you serve them?
We'll serve a copy on them, my lord. Notice has already been dispatched to the registry. In addition, we can serve them a copy, my lord.
Just say the notice to
Please,
respondent number 1 to 4 has been
That has
dispatched by
been
the
dispatched, my
registry
lord, awaited.
to await the service report list on 16/7 along with
Writ
those
appeal
writ appeal number. When those.
1722 of 24. My lord, 44 and 46 are also the same matters.
44, 46 are same.
Same.
Same order in 44 and 46. Ma'am, just note it down, huh?
Forty-five. Serial number 45.
From the legal service committee, my lord, for the complainant mother, please, my lords.
I have a grievance, my lords. Can I state my grievance first? Despite a complaint memo filed by me last time, I have not been served the entire annexures of the main petition. The compliance of Rule 8 has not been done.
Was the file?
Forward, in addition to that, she has filed 3 more memos. I have got the certified copy now. I don't have all the annexures. In fact, the annexures are not matching with what has been served. And she has filed 2 more, even after the complaint memo.
My lords, I have given the complete acknowledgement to this honorable court, and may I take this honorable court to the observation made by the trial court that the advocate is very famous for making these kind of false submissions, please, my lords. All the 4 memos and the recent one, my lords, even on the 23rd, I go to the apartment of the accused, give him the notice by hand. My lords, the photographs are also submitted. But on 27th, he puts a memo and says that he has not received anything. And again, my lords.
Ma'am,
after
you'll
all
do
the
one
memos-
thing. We are passing it over. Get another copies of all these memos.
Sure,
We'll
ma'am.
pass over. Just give it to him. He will. Then
I'm
we'll record
obliged.
it.
I'm
Pass over.
Grateful, I'll do it.
47.
Yes, Mr. Ravi Shankar.
Lords, in a writ petition which was filed by 3 of the members who were held ineligible to vote in the elections of a cooperative society, they approached this honorable court. Lords, by contending that the procedure for the purpose of preparation of the ineligibility list was not followed. On that premise, an interim order was granted that they will be permitted to vote subject to the further final outcome of the writ petition. When the writ petition was pending, we filed an impleading application and filed our objection saying that they have not in fact appeared in any of these meetings. So then they made an amendment saying that because of the COVID, we were not in a position to attend to the meetings. That is the amendment which they brought about minutes after we filed our objections. For that, we also brought it on record that out of 157 members, 147 participated in the election, meetings, which was held even during the COVID period, because we had provided them with specific links where they could easily log in and they could participate in the meetings. Only 10 of them did not attend in these two meetings. Out of 10, 3 came before the court. Then, this was a disputed question of fact as to whether or not their vote should have been counted to declare the results or not. First of the case which came about by this honorable court was, of course, Mohammed Berry's case was the first case. Relying upon an earlier judgment of Sant Janardhan's case by the Supreme Court saying that preparation of an electoral roll forms an integral part of the election process insofar as a cooperative society is concerned. Therefore, High Court should not interfere with the matter. One exception was carved out to these principles after Mohammed Berry's case in Ganganna's case by a learned single judge, which took the view that in the ordinary course 226 should not be exercised, more particularly if there is a requirement of giving some findings on the facts or disputed questions are there, or the contentions in the petition itself is being disputed, question of entertaining 226 would not arise. Parties will have to be relegated to section 70. That is, the petitioners will have to be relegated to section 70. These judgments were placed before the learned single judge and said whether they were in fact prevented because of the COVID is a matter which is required to be decided and which is to be done. We placed on record our statement of objections to say how the facilities were created, why there could not have been any possibility that they could not have attended the meeting if they did not want to attend the meeting. Learned single judge now says, it's just a short judgment if your lordships were to see. The single judge's order commences from page 16. At the page 36, the point for consideration. Point number 1, sorry, page 36, which would be internal page 21 of his lordship's judgment. Para 13, whether a dispute raised in relation to eligible or ineligible voters list published by the society can be considered in a writ petition, whether in the facts of the present case there is a requirement to direct the votes cast by the petitioners to be counted while announcing the results in the election. Two contentions. Then, answer to point number 1, the aspect of whether a dispute as regards eligibility or ineligibility of the voter as indicated in the voters list published by the society can be considered by this court or not has been answered by the coordinate bench in the court of Ganganna and T. Sampath Kumar Achar, wherein this court has categorically held that the dispute can only be raised under section 72 of the Act and not in the writ court. Thus, I answer point number 1, holding that the dispute as regards eligibility or ineligibility of a voter officer as published in the voters list would have to be considered only in a dispute raised under section 72 of the Act, and it is only in exceptional circumstances that this court can exercise the jurisdiction by way of a writ petition. Not that exception is carved out, but that is always there, because it's a supervisory jurisdiction which the court exercises. It's always there. It's a plenary jurisdiction. I should not say supervisory. It's a plenary jurisdiction. Then answer to point number 2. Notice if your lordships were to see 16.4 and 16.7, this is where the difficulty comes in. Under normal circumstances, this court would have intervened in the matter at hand, would not have intervened in the matter at hand, except that 2 of the last 5 meetings have been held during the COVID period. And as it is known to one and all, it was difficult during the COVID period for any person to travel and attend the meetings. And there were also restrictions in relation thereto. COVID period would have to be considered differently than the normal period, and the non-attendance of the meeting ought not to in such circumstances be held against a member so as to hold such member ineligible for voting at a meeting, which is a democratic right vested. A perusal of the facts in Ganganna's case indicates ineligibility therein was on counts of 22, A4 and A5 is one which relates to non-availability of the services by the member, etc. Then 16.7. In the present case, admittedly, the ineligibility of the petitioner is only on account of violation of 22A4, which has dealt with supra. In that view of the matter, I am of the view that the opinion taken into account during COVID pandemic and not taking into account 2 meetings that were held during COVID pandemic, non-attendance by the meeting of the petitioners cannot help to deprive the exercising their democratic rights. The elections to the union occurring once in 5 years, delegate of the petitioners or primary societies ought to have been entitled to vote in the elections of the union so as to exercise their democratic rights. Now, Lords, may kindly take my statement of objections at page number 148. Because we had already placed materials. I can understand, Lords, if the learned single judge adverse to this statement of objections and then gives a finding of fact, then my grounds for something else. At paragraph number 8, at page 151.
Yes.
No, the first meeting was held not during the COVID period, but nonetheless, only one meeting was held during the COVID period. It's not the 2 meetings. Then paragraph number 8. In pursuance of compliance of the notices, 5th respondent has prepared the list of eligible and ineligible voters list of the members of the 5th respondent union with respect to Malvalli constituency, wherein total numbers are 151. It is pertinent to mention here itself that due to COVID-19 pandemic, 5th respondent union has arranged a separate video conference meeting in each constituency, including Malvalli constituency. In total of 151 members, there are 10 member societies who are not attended the general body meeting, including these petitioner societies also. The copy of the ineligible voters list is produced as annexure R8. Then paragraph number 11. The amendments made, it's because that's where they made a statement that this COVID was there, etc. That is what we have adverted to minutes in para 11, 12 and 13. The amendments at 6A, 6B of the petition amended paragraph subsequent.
The elections were held?
The elections were held. In the usual course, what even in Gangana's case, even the subsequent judgment of a coordinate bench, in Hemavati's case.
Who are you?
I am
successful.
Yes. Now, the entire electorate depends on the counting of these 3 votes. If these 3 votes are not counted and they are relegated to agitate their disputes under section 70, the things will be completely different.
Materially, this absence will materially affect the election?
Completely. Not materially, it will completely affect the elections. 3 votes, if it is excluded.
It means it would substantively affect the election outcome.
Yes, it will be topsy-turvy. One is there, the other one will come. It's as simple as that. Lords, considering these submissions, your Lordships granted an interim order. When the matter came up during the vacation bench, your Lordships have granted an interim order that let the election of the office bearers can go on, but the result should not be declared. But I have a submission to make, Lords, because I should stand. I am also a part of the society. I cannot stand on that. I am not contesting for the post of president. I am only for the vice president. There are only 2 office bearers, president and vice president. So far as president is concerned, Lords, it can be declared. Lords, this is all my submissions. Another 5 minutes down the line, Lords, I'll be completing my submissions by referring to 2 judgments of course, it's by the learned single judges of this honorable court. I'll be referring and being done with this. But this is something, Lords, which I will have to bring to your Lordships' notice. So far as declaration of results of president is concerned, I am not in any way concerned because the person who will be deemed to have been elected if these 3 votes are excluded will be the petitioner. That's where we stand, Lords. Now, para 11, 12 and 13, there is completely a para 13 in particular, 12 and 13. We have given, sorry. September 2019.
This is for federation.
Please, my lords.
Federation of
Yes.
milk producers.
Yes.
Not a federation, it's a union.
Oh, it's a union. But the electoral college consists of all these
primary societies. It will consist of all the primary societies. Now, 3 primary societies who came before the learned single judge came only with a contention that the procedure for preparation of the ineligible voters list was not prepared in accordance with law.
The elections held?
What's the elections? 2nd February 2025.
Now, between interim between 920 when COVID had happened until 25, you were not knowing about the electoral college or electoral list.
Lords, it gets prepared when the elections are declared, my lords. 5 years is
15
the
days
term.
prior to.
And the term is getting expired as per the rule 13, my lords, before previous 195 days or the procedure starts. That is when the objections are called for from the ineligible voters. And this is elections to the federal society where all these primary societies send their delegates.
That's right.
Let's see, in other words,
Now election to the members are also done, office bearers are also done, my lords. Now the board has to be constituted. Now, my lords, by virtue of the interim order.
I just want to say this, my lords, just to supplement what the learned additional advocate general submitted. 195 days prior to the date on which the elections are due to be held, the persons concerned will be notified. So 195 days earlier to the date on which the notification was there, that is 6 months and above, they were aware of the fact that they were ineligible. They never came before the court. They did not file their objections to the notices which were sent. We placed the notice.
How do you say they were aware they were eligible?
Notes we have produced the postal receipts for having sent these notices. Then that's the reason why I said, if the learned single judge returns a finding saying that there is nothing to show that the procedure has been followed under Rule 13D2 capital A for issuance of notice, receipt of notice, then it's a different matter. Because if that is not the finding which is returned by the learned single judge, I am not at risk before your lordships to. But still, my lord, since your lordships asked this question, I am just saying this. We produce materials to show notices were served, notices were issued, they were served, they did not file their objections. They did not file their objections, and 15 days prior to the date on which, my lords, the elections were held, the final list of ineligible voters was published.
Finding on that by the
No, there is no finding on that by the learned single judge. Learned single judge only goes on the principle of COVID. Notice, if your lordships were to see para 11, 12 and 13, we have specifically said COVID has never come in the way of the meetings.
For objections on the electoral list.
Yes. They never filed their objections. Now the procedure is contemplated.
Name was also there.
It was there in the ineligible voters list. 6 months in advance, it is there in the ineligible voters list.
Ineligible list.
Ineligible voters list.
Okay. Who appears for the petitioner before the learned single judge? Mr. Patil, you appears?
Please.
What is your case on this submission of Mr. Ravi Shankar? The notices for ineligibility, the voters list are being ineligible.
Case of the petitioner says they have not received any notice with regard to that ineligibility list, 13D2A list.
Oh, they had not issued. But once they say that they have taken such a stand.
Paragraph number 5, 6 and 7 at page 150. Statement of objections, my lords.
5, 6 and?
Para 5, 6 and 7.
You see page 150, Mr. Patil.
Please.
We have produced the documents also.
Union alla.
Paragraph 6 you will see.
Yes.
Paragraph 6.
Please.
150.
The fifth respondent union, in consonance with Rule 13 of the rules and also provisions envisaged in so and so, had issued final notice dated so and so, informing the petitioners that in terms of so and so they are. On the other hand, your lordship may kindly see page 50.
Page
50.
Yes.
That is the writ petition copy.
Yes.
Para 9.
Hmm.
It is submitted that since no notice was issued to the petitioners as per Rule 13D2A1 of cases rules, they were unable to file their objections to the said draft list of ineligible voters regarding non-attending of the annual general body meeting.
Did you file rejoinder to their counter?
No.
Rejoinder was not filed because the authority which is to issue the notice and do all those things is the Cooperative Societies Union. It was not a statement by the
Para 5 and
respondent number,
Yes.
respondent number 5.
Para 5 and 6, the documents are produced, Binots. The notices are there, postal receipts are there.
But tell us one thing, Mr. Ravishankar, what is your locus to issue notice?
Milords, we have not issued notices.
they
The
can't
procedure,
issue.
Milords,
They
the
can't
procedure
issue
is,
the
we have not issued notices. The notices will be issued by the concerned society. The procedure is, the CEO of the concerned society will have to prepare the list of eligible and ineligible voters list. Eligible voters list, no difficulty.
Of that particular society?
Of the particular society, he will prepare. Milords, for that purpose, CEO will be an election officer. He will be a part of the election process. He prepares the electoral roll. After he prepares this list and then sends it, then he has to send notices to all the persons who are in the list of ineligible voters, calling upon them to give their explanations. He will receive the explanation. If at all anybody has given a reply saying that, no, whatever you have said in the notice is not correct, I should not be in the ineligible list. You
Tell
should
us
be.
one thing, we want to be clear. This is for the union. It's like a federation, the
Milords,
umbrella body.
Milords, the federation only prepares. The federation will have a CEO. Milords, now the federation is consisting of the primary societies as its members. That's it. So federation will have a CEO. Federation will exercise the same rights. The CEO of the federation will prepare the list of ineligible voters who will be the primary societies, whose delegates would not have attended the meetings, or whose societies would not have availed the minimum services, or who will be at default. These are the three kinds of defaults on account of which they will be in the ineligible list. Now, he issues notice to these members, societies, 6 months in advance, calling upon them to show cause as to why they should not be, they should be retained only in the ineligible list. If they submit their objections, it will be placed before the officer concerned under the scheme of the Act. Officer will then finalize the list of ineligible voters and the eligible voters. This exercise has been undertaken. Now, once this is a fact-finding exercise, Lordships may kindly see Rule 13D2A. If this is the elaborate exercise to be undertaken, materials were placed before the learned single judge to show that this exercise has been undertaken, then anything else, Milords, would be a disputed question of fact, which the coordinate bench, Milords, of the learned single judge took the view that it should not be done. Kindly have a look at the Rule 13D2A.
But the electoral college consists of each of the societies.
Yes, electoral college is only the primary societies.
Primary societies. Now, it is the stand of the primary society, what Mr. Patil has read, they have not received any notice.
Yes, now this is what they said. Learned single judge doesn't give this finding. I can understand, Milords. Their pleading was there. My objection was there. I have placed my documents before the learned single judge. Learned single judge should have dealt with that matter if that is the contention to be raised. Or if that COVID was to be a contention, then my objection should have been considered as to whether the COVID came in the way of any of the other members participating.
What is your stand on that?
On COVID, Milords. COVID, Milords, that's what I said. Para 11 and 12, if your Lordships were to just see, Milords, para 11 and 12. I'm sorry, para 12 and 13. But I'll just kindly pardon me, Milords, if I were to read from para 11 and onwards, it's just the amendments in para 6A and 6B, which was the subsequent amendment for where after we filed our objections, Milords, I just want to say this. First, they said they were not served with the notice. We produced the copies of the notices saying that you are served with the notice. After that, they filed the amendment saying, no, it is not because of the notice, it is because of the COVID that we were prevented from attending the meeting. That is para 6A and 6B of the amended writ petition. Now, Lordships may kindly see para 11. The amendments made in para 6A and 6B of the petition was amended paragraph subsequent to the interim order passed by this Honorable Court dated 22/1/25 permitting the petitioners to cast the vote, which itself shows the petitions have created new facts with regard to first general body meeting conducted during COVID-19 and further alleged that the petitioners have conducted 4 general meetings of 5th respondent out of 5 meetings. It is submitted that the previous board election was held on 8/9/2019 for a period of 5 years. And on the very same month, that is September 2019, physical general meeting was held on 23/9/2019. Therefore, the question of COVID pandemic did not arise for the first meeting. Hence, it is crystal clear that the petitioners are trying to mislead this Honorable Court by creating new facts and grounds in the form of amendment, that too after granting the interim order. Therefore, the question of non-consideration of annual general body meeting as per 20 of the Act does not arise. It is needless to mention here itself that 2021 COVID pandemic, Fifth Respondent Union made available video platform to all 151 primary members of the Malvalli constituency, including the petitioner society, and this respondent to attend the meeting, and there was no poor connection as alleged by the petitioners. Otherwise, out of 151 primary societies, only 10 members have not attended the meeting, which is less than 5% of the Malvalli constituency. And in the ineligible list of 7 members have admitted that they have not attended the meeting and therefore they have not approached the authority to cast the vote in the elections of Fifth Respondent Union. It is clear that the petitioners are making false and baseless allegations and put to strict proof of the same. Notice, if they want to show that because of poor connection that the facility, because the government circulars were issued that the general meetings will have to be conducted through video conferencing. We issued video conferencing, links are provided, 151, 141 have attended. Then it becomes a question of fact whether there was any such thing which prevented them.
What is the relevance of the meeting?
No, its relevance is under section 22A4. The requirement is that a member to vote in a election should have attended 2 out of the previous 5 meetings for being eligible to vote. That essentially means, the object is that was challenged. The constitutional validity was challenged, which was upheld by a learned single judge.
So what you are saying is, not attending the meeting is a disqualification.
Yes.
Now, last 5 meetings, how many meetings they have attended?
Only 1 meeting.
Out of 5?
Yes.
So you say they were ineligible. And what is the stand on ineligibility?
Lords, if your lords were to see page 50, which was referred to, if they had made a statement that their contention is twofold, if they come to the court with a positive stand saying that on the first instance, because afterthoughts will always be there, because as and how the case develops, they can't develop these afterthoughts. If they had made a statement when they came before the court saying that we attended 3 meetings, on so and so date we have attended, for XYZ reasons they have not noticed. If this is their plea, I can understand. It is not their plea. Their contention is that 13D2A procedure is not provided, therefore this list has to be faltered. They should say, we have attended all the meetings.
Which say 13?
13D2A. Rule, my lords. Lords, may I just take your lordships to section 22, my lords, section 20, subsection 2, so that the procedure can be understood, my lords. Section 20, subsection 2. May I read it? Sorry. Section 20.
Yes.
No member, no representative, no delegate of a society shall have more than 1 vote in the general meeting or in the election of the members of the board. That is 20, subsection 1. 2. The following shall not have the right to vote in a general meeting or an election of the members of the board of the cooperative society in which they are the members. Notes, I will skip A, A1, A2, A3, and then I'll go to A4. A member, a representative of a delegate who has failed to attend at least any 2 annual general meetings out of last 5 annual general meetings duly communicated to him. A5 is also, because these were the insertions made after a constitutional amendment came about. Constitutional amendment went, but the provisions have remained in the statute. Now, your lords may kindly see Rule 13D2A, because validity of 22A4 was challenged on the ground that it does not lay down a fair procedure as to how the ineligibility has to be decided. That when that question came about, when that matter was being adjudicated before this honorable court, the government came about with the proposal to amend the rules to introduce the procedure how this ineligibility has to be determined. 13D2A, my lords. The election officer shall take steps for publication of voters list who are not eligible to vote in the following manner. For publication of draft ineligible electoral list, Chief Executive of every cooperative society shall prepare notice in respect of members not attending 3 out of the last 5 annual general body meetings and members not utilizing such minimum services or facilities in a cooperative year as specified in the bylaws for 3 consecutive years. chief executive of every society shall send the above prepared notice to all ineligible members 15 days prior to 6 months, that is 195 days. To the date of election of the board by registered post, and an opportunity shall be given to such member to file their objections, if any, within 15 days from the date of notice. The chief executive of every cooperative society shall submit the list of ineligible voters to the election officer along with their objections, and also produce the records pertaining to their absence from the general body. This is general body meeting with attendance and services utilized by the members. He has to produce the records for having sent the notices along with the acknowledgement for election officer within 30 days from the date of election notice. Chief executive of every cooperative society shall state in his notice that eligible voter can appear before the election officer between 30 days. Election officer has to hear and dispose of the objections. Final list of ineligible voters shall be published on or before 15 clear days before the date of the election. Para 5, 6 and 7, we have said this procedure is complied with.
So the results have not been declared?
Yes,
no.
My lord, one submission.
My lords, I'm sorry. The results are results of the election to the board of directors.
Pursuant to the order of the learned
yes,
single.
Yes.
After the board of directors are constituted, there is a requirement of electing the office bearers. Election to the office bearers, my lords, is permitted to go on, but the results are withheld. Now, the person who is won with these 3 votes, he will be the person who is going to contest, who is contested for this post of vice president, and he will eventually win it. This is the difficulty. And he is a person who is won on the basis of an eligible voter. If these 3 persons had not come before this honorable court, he would have been out.
No, your case is because of the directions, because of which his eligibility has been determined, the
Yes.
re-elections have been held.
Yes.
Otherwise, if the original stand of yours is upheld, they are out.
They are out.
That has to be decided in the dispute, my lord, not here.
Pardon?
That has to be decided in the dispute because evidence is required. My lord, the competent authority to say whether they have sent notice, everything is before the society has to come and say whether they have served the copy or anything.
So what you are saying is the elections results be declared and let anyone who is aggrieved.
They can go on, yes.
A remedy.
Dispute, they
Yes.
can raise a
But
dispute.
There's one thing, Mr.
Yes.
Ravi Shankar. Dehouse your substantive argument, the first election was right, justified. What is the difficulty if the result is declared?
Lords, now the person who has won the election as a result of the orders of the learned single judge, which is impugned before lordships, eventually is going to be the director, and he will be the. Lords, he was not. Lords,
results have
that
not
3
been-
votes is what has turned.
His right is not curtailed, my lord.
Results have not been declared.
Lords, the results are declared to the board of directors. Lords, two things. One step is board of directors. Board of directors inter se will elect the office bearer.
President and vice president.
Now, board of directors results are declared, no difficulty. Now, so far as office bearers is concerned, my lords, after considering these submissions, this honorable court said that let there be no election to the board of directors.
Board of directors, these 3 voters are not there.
My lords, in the board of directors, in the election to the board of directors,
It is implemented.
my lords, in the election to the board of directors, these 3 voters have participated in the election to the board of directors. Now, if these 3 votes are to be excluded, if learned single judge's order is to be interfered with by your lordships, and this order is set aside, then the results pertaining to Malvalli constituency requires to be redeclared by discounting these 3 votes. That is all what requires to be done. Because it is constituency based. Only these 3 votes has to be excluded.
No, but tell us, how does this electoral system works insofar as this concern?
My lords, now so far as a cooperative society is concerned, my lords,
Yes.
the process of an election commences from the preparation of the electoral roll. Unlike under the representation of.
At what level? The society level?
My
Individual
lords,
level?
now I will just, my lords, there are tiers in the society. My lords, there is a village level, then a taluka level, a district level, and the state level. My lords, this is milk union. There is Vyavasai Seva Sakar Sangha, Lords, and then DCC banks. Like this, there are various tiers with which it is there. Now, a primary milk society will be a member to the federation, which will be a district federation usually, which will have constituencies, taluk-wise constituencies. So the members of the district federation will be the primary cooperative societies in a respective village or a hobli, and they will be the electorate for the federation.
They will send out.
Federations will in turn be the electorate. There will be multiple federations across all the districts. They will form the electorate for the union, which will be the state union. So there is a primary society, there is a federation, there is a union. Three tier insofar as milk union is concerned. Now the primary societies are again subdivided into constituencies based on territories. Now let us assume, my lords, that it is for Bangalore district. So now for various areas, based on territorial limitations, they will describe that whichever societies are operating in a given territorial area, they will form one constituency. So it is divided into constituency. Now, so far as the present Mandya is concerned, this is again, my lords, divided into various constituencies. We are concerned with only one constituency, which is Malvalli constituency. In Malvalli constituency, there are 151 societies for this. So the total electorate will be 100, total membership is 151. Now the process of election commences by preparing the electoral roll. That is when the electorate for the election, my lords, will be decided. It is for that purpose, my lords, that Rule 13 is designed, which shows two procedures. One, procedure for drawing up of the ineligibility list in so far as the persons, members who have not participated in the meetings, number one, or who have not availed the minimum services, number two. For that, there is a distinct procedure. The other category of persons who gets disqualified are the ones who would be defaulters, who would not have paid. 50% is the minimum which will have to be paid. That default will be there. So an elaborate procedure is followed, which is required to be followed 6 months prior to the date on which the election is to be held. So this is where it stands. Not say election process should not be sabotaged, by the orders of the court.
All the parties are represented?
The
Yes.
present situation is this, Madam. Pursuant to learned single judge's order, results have been declared. It's implemented. Thereafter, office bearer selection is held. In that, as an interim objection, my learned friend says is, the person who has succeeded before the learned single judge is likely to become vice president. Therefore, that result should not be declared. That may not be this thing. And one other aspect that I bring to your lordship's notice is the order with regard to COVID period is an order passed in not less than 500 cases. In all the cases, learned single judge, not only the learned single judge who passed this order, even other learned single judge have taken the view with regard to absence of general body during this period of COVID, it will not be taken as this thing. The other party may go to dispute if they are so aggrieved. And that has been done in hundreds of cases.
Thousands
of cases.
I just wanted to interdict here, my lords, in respect of the very same federation. This is pertaining to Malvalli constituency. Pertaining to Maddur constituency, the very same learned single judge says that the COVID period is not something which can be reckoned, and the writ petitions are dismissed by directing the petitioners to approach. Your lordships may kindly see there are divergent views taken by the very learned single judge pertaining to the very same federation, pertaining to two different constituencies.
No, all are represented?
Yes, my lords. As
So
things
today there is
stands,
a restraint order against them. Office bearers shall not be named.
that's all, my
The
lords.
office bearers include the vice president.
Yes, lords, I'm making a statement since vice president, the person who's been elected with these 3 votes is not the person contesting for president. It will not be reasonable for me to make a request that this should be continued for the all the other office bearers. It can be restricted only to the vice president. Other office bearers can start functioning, lords. I'll not come in the way.
No, but in any case, insofar as vice president is concerned,
Yes,
that can be restrained.
That can be restrained.
Can continue.
Yes, my lord.
Till such time we hear this.
Please, my lord. Your lordships may fix a short date, my lords. I don't
To
think I'll
have
make.
Mr. Patil, you have ma'am any objection on what that they say?
My
Other
lords,
office
my-
bearers,
my-
there is no contest.
My lords, my only submission is that would be a piecemeal submission, because I'll point out, my lords, all the arguments learned senior counsel has pointed out to my lords is there is no case of non-compliance of 13D. Primarily, they are not the federal society to say that. Secondly, my lords, the learned single judge in the order para 16 onwards clearly says it is a specific case, and he considers only because of this COVID. If my lords may permit me to read para 16 onwards, which was not read out to my lords, page 38.
16.3 at page 39, the learned single judge records a finding.
My lords, para
One minute, ma'am. We'll do one thing, we'll set out for hearing, file your submission. Let's understand the system, how it
My
works.
lords, both the office bearers may be permitted, subject to the outcome of the writ appeal. It would not harm them.
Lords,
The
a
office
person
will run.
who has.
No, what is the prejudice is being caused because of the interim order which is in play? What is the prejudice?
My lords, he is not even contested for vice president, the person before my lords.
He has not,
Not contested. What will he achieve?
you have not contested for
Lords.
vice president.
Lords, we have not contested for the vice president, but we have filed the impleading applications to say the 3 votes should not be counted for the purpose of constitution of the board of directors so far as Malvalli constituency is concerned. Now,
If he was
the
a
board of
rival
director from the Malvalli constituency is the person who is won only with these 3 votes. The difference is only these 2 votes. 2 votes is difference. Lords, the total difference between him and the next candidate is 2 votes. If these 3 votes are excluded, he automatically comes up.
Who will come?
Lords, I'll be the person who will be coming
He is
up.
not contested. He is not
No, for
contested.
director.
He is eligible for office
Mr.
bearer.
Ravi Shankar, see, tell us one thing.
Might
Lords,
become
I
a
will
mere
be declared. Lords, I
academic
will be
exercise
declared
later.
elected.
It might become an
Lords,
academic
I will be
exercise.
declared elected if these 3 votes are discounted
Elected for what?
to the board of directors. I will be the board of director. Lords, a person who is.
1 minute. So we understood you. Once you come in the board of directors, you can contest for any of the
For any
office.
of the posts, but now I am
For
saying,
president
Lords,
and
that
vice president.
I am not coming in the way because I understand the limitations. The fairness I am submitting that since the person who has won with this 3 votes is a person who is contesting for the vice president, let that not be there. I am taking the chance. Lords, there is already an interim order, but I am saying, Lords, that it's okay. I will.
So what we have understood is, if you had come in the board of directors,
I would have contested
but
for vice
for these
president.
3 votes, you had not come.
Yes.
Once you come in the board of directors, the office bearers field is open to you.
Yes.
Whichever you want to.
I can contest.
Contest.
Yes, I can contest for
But
anything.
You are more interested in vice president.
Yes.
That's what your submission.
Yes, my lords.
So what their plea is that you did not contest for vice president would not arise because you had not come in the board of directors.
Yes, I could
That's
not
what.
come because of that 1 vote. 2 votes is what he is won with.
We'll hear it, I think, ma'am. We'll fix it after 2. You file your submission. Let's
Please,
understand.
Lords, I
the
shall
system.
file my written submissions in this regard.
The board,
All are represented?
Yes, now all are
let
notified
the
and
board be constituted, my lord.
My lord,
since constitution of the board has taken place.
We want to understand that.
From
No.
1 year, there is
1
a,
minute, Mr. Patil. You have heard him also. He says he has no difficulty minus vice president, all the member office bearers be constituted. He says so. You have anything to say on that?
of course, my lord, all that I would respectfully submit is, my lord, if it is made subject to result of the petition, automatically it would, subject to result of the appeal,
You're right,
it would
that-
automatically. Otherwise, your lordship may confine it to at least
Vice,
president.
yes.
No, in any case, that can be done. But the only thing is what is being said is your case for any prejudice that office bearers are not in place. That can be obviated. What he is saying is, according to him, minus vice president, rest everyone can come in.
Come in.
Except vice president, you can. So that at least there is something in place
Yes.
as office bearers. That's what he's saying. What do you say?
Vice president anyway, my lords, is only in the absence of president. His powers are very limited. Only in the absence of
What are
president he
you saying?
actions.
What do you say? We elicit your response.
Response is, my lord,
Or we fix it, finally hear it. That's other
your
option.
lordship may confine it to president if your lordships feel that.
We are not. We are seeking your view on this. That's a submission. We are seeking your view.
Vice President between.
That's what.
Of course, my lord,
Tell us one
we
thing.
don't want to come in the way of board being constituted. Let the
That's what.
board be.
Now, we take it that there is no challenge in any other challenge with regard to this election?
No, my
That's
lords.
also we want to know.
No, no,
No.
there's no other challenge.
Now, what is the interim order that has been passed?
Director continue.
Now, tell us one thing, the order, if you see that 15th of May order.
Yes, my lords.
The second page, third paragraph,
Lots.
third line from the bottom. There is a force in the contention of the learned counsel for the respondent that let the office bearer's election go on, but results shall not be announced without leave of the court.
Yes.
When such being the case, since already election results are declared and the date is fixed for election of office bearers, let the office bearer's election go on and the result shall not be announced without the leave of the court in respect of respondent number 5 union. And this order is passed in view of the summer vacation. Now, we have understood you is the result of the office bearers of all posts except vice president.
Except
be
vice
declared.
president, that's.
Can
Please.
that be passed?
Yes.
Of course, my
What
lord,
do you
he
say, ma'am?
he appears for the
Vice President.
respondent
Union.
Union. I appear for the party who has succeeded.
Now, ma'am, you appear for whom, ma'am?
State.
Returning officer statement.
State and
You see-
returning.
You see the memo. 1, 2 would be, you would be appearing?
Two
Two is Kiran Kumar is appearing.
Acha, 2 you are appearing. Election officer?
1, 3,
Statement.
1,
1,
3
3
and
and
4
4
is
is the
state.
state. And 2 you are appearing, Mr. Kiran.
Yes, my lord.
And who appear, Mr. Patil, you appear for 5?
respondent number
5,
5.
5, my learned friend appears. Tahir appears for
7 and
6,
8.
7
We
and
are
8.
appearing for 6, 7 and 8. Respondent number 5.
I appear in. You appear.
All are represented.
Now, this direction on 15.5 is directed against whom?
This direction would be,
Against the.
of course, it is the returning
Authority
officer who will announce.
R4,
It
my
is in
lords.
respect of respondent number 5.
Five.
We are
That's
concerned
R3.
with respondent number.
Lords, R3 in relation to R5. The direction will be essentially against
R3.
R3.
R4.
Returning
Returning
officer.
My lord's direction is to the returning officer
R4.
not to declare.
Please.
Now, 6, who appears for 6?
I appear for 6, 7 and 8. my lord.
So
They're all
if you are
primary.
agreeing, if all of you are agreeing, we'll record your submission that the order of 15.5 can be varied, modified to mean that the election, the result of the election of office bearers to respondent number 5 society, except for the post of vice president, can be declared.
Please, my lords.
Will
Please.
that be agreeable?
Please.
Yes.
Please.
Just say this. We have heard the learned counsel for the parties for some time. It is agreed by the learned, just take the appearance of everyone. It is agreed by the, our attention has been drawn to the order dated 15/5/2025, wherein this court has at page 2 of the order, just the last paragraph. Ma'am, just last paragraph. Has passed the interim order in the following manner. So the learned counsel for the parties agree that that the aforesaid order passed by this court on 15/5/2025 be varied to mean that the election result be declared by the respondent number 3.
4.
Respondent number 4. Election of the office bearers of the respondent number 5 society be declared by the respondent number 4
Please.
for all posts except vice president.
Please, my lords.
That's right?
Please.
Their submission is taken on record. Full stop. In view of the issue which arises for consideration, appropriate shall be the counsel for the parties shall file the written submissions along with the judgments they want to rely upon. List this in first week of July.
Please, my lords.
I'll have a copy of this order.
We'll just upload it. Thank you.
Much obliged.
8, 7.
This case, my lord, I appear for respondent number 1 and 2, my lord. I pray for time, my lord, to file objections, my lord. Monday night, they have served us copy, my lord.
No, no, my lords, this was filed in vacation, my lords. There is an urgency for me, my lords, in this matter.
Let's see.
They have served us this copy.
What is the urgency, Mr. Tiwari?
My lords, my lords, obtained a conversion order showing a road in my property. My lords, my lords, conversion order was subject matter challenge before the deputy commissioner, my lords. The deputy commissioner conducts a spot inspection and says that this has been obtained by fraud and set aside the conversion order, my lords. Now that is subject matter challenge before this court, my lords, by the petitioners. My lords, the learned single judge, my lord, says that the deputy commissioner does not have the powers to review his orders and disallows the petition and set aside the order of conversion, my lords.
Let's see that order.
Yes, my lords. Please look at, my lords, impugned judgment. At page 31, my lords. No. Please look at page 31, my lords, impugned judgment. The operative part, my lords, is at para 12 at page 41.
Conversion order is from which identity of land to what?
My lords, there was a conversion from non-agricultural to agriculture, non-agriculture, my lords.
Agriculture to
Non-agriculture, yes, my lords. That was, my lords, obtained showing a road in access road was shown to that property, my lords. Why my property? My property is on the main road, my lords.
Was that order passed?
1996, my lords.
But when did you challenge it?
2024, my lords.
Why so late?
My lords, the reason is twofold, my lords. One, I was not residing in India, my lords. I came to know about it, and I was not aware of this at all, my lords. I was not aware of it at all because, my lords, they are the adjoining owners. Now, my lord, someone had obtained a conversion based on my property, my lord. I was not even aware of it. When I wanted to develop my property.
But tell us one thing, Mr. Tiwari, you would not sit idle now from 96 to
My lords,
24.
my lords, spend majority of my life not in India, my
That's
lords.
no reason.
That's what my ground is, my lords. Number one. Number two is, my lords, when I went to develop my property, is only then I realized, my lords, that someone had already obtained a conversion based on my property, my lords. May I just show the sketch, my lords? But more importantly,
Yes. Now, what is the urgency?
the urgency is, my lords, today I want to develop my property, my lords. So are they developing their property? No, my lords, if they develop their property, my lords, showing a road in my property, my lords, I won't be able to develop my property tomorrow at all, my lords. That is the nature, my lords, why that is the urgency that we are pleading today. May I just show the sketch, my lords? May I just show what is the problem? Please look at, my lords, the sketch of what they have obtained at page 283.
Did they plead adverse possession?
No, my lords, we are adjoining owners. I had nothing to do with properties.
Say for 96, 12, 24, you don't even.
I was not aware, my lords. I was not aware of it. It is not my business to know what's happening in the adjacent owner, my lords. If they have got conversion in the adjoining property, how would I know, my lords?
Lord, shall I make a submission? Lord, after disposal of this writ petition, my lord, they have filed appeal before Karnataka Appellate Tribunal, my lord, by challenging the conversion order. They have suppressed that fact and they have filed this appeal, my lord.
No, I'll come to that.
They have already challenged the conversion orders.
May I, my lords, may I say this, my lords? The entire order, my lords, of the learned single just proceeds from the fact that the deputy commissioner doesn't have the powers to review his own orders, my lord. That is the only ground of it. My lords, that was correct prior to 12/1/2023. Deputy commissioner has no powers to review his own order, my lord, prior to 12/1/2023. That, my lords, went through an amendment after 12/1/2023. Now that, my lords, has been missed by the learned single judge, nor was it pleaded, my lords. The only sole reason that the learned single judge says the deputy commissioner doesn't have powers. But that is not, my lords.
First, tell us one thing. If there was no such power granted to the deputy commissioner, you could have challenged it.
My lords, the order was passed after the amendment took place. All the spot inspections happened, everything happened, my lords, after the amendment took place, my lords.
But what was the earlier order passed by the deputy commissioner?
Deputy commissioner had permitted to conversion, yes, my lords, 1996.
In whose favor?
In petitioner's favor, my lords.
So how are you agreed by?
Because, my lords, they have obtained a conversion order showing an access road in my property.
That's the only thing.
That's the only thing, my lords.
But that will materially not affect the conversion order.
My lords,
Principally, he is entitled to the conversion order.
my lords, if today, my lords, they could not have obtained a conversion order without showing an access in my property, my lords. May I just show, my lords? May I just show what is the? May I just show the sketch, my lords?
Lord, they made a wrong submission. Conversion was obtained by my vendors, my lord, not by me.
No, but in any case, it will be inter se only between both of you.
Yes, my lords. Because may I just show 283, my lords, page 283 to show the conversion, my lords. What is the
What
sketch?
is-
Page 283, my lords, volume 2, my lords. It's in volume 2.
My lord, kindly grant me 1 week time, my lord, I will
Yeah,
file
yeah,
object.
What is your urgency now?
My lords, I'm trying to develop my property, my lords. I'm unable to develop my
1
property.
week, 2 weeks will make any difference?
My lords, they are developing their property. No, my lords, their property is subject to development now, my lords. They were going at a great pace, my lords. Now I won't be able to develop my property, my lords. This is,
Right, we will give him some time, surely. He should require some
my lords,
time.
this was filed during vacation, my lords.
9624, you don't do anything.
My lords, my lords, I understand, my lords, 1996 order. But my lords, may I suggest only one thing, my lords? Today, my lords, there cannot be no dispute, my lords, that the deputy commissioner has no powers to review his
We
own
will
order.
look into it.
Well, may I say something, my lords? When there's a power, my lords, when the statutory power is there to review his own orders, my lords. When there's a power, my lords, all I'm suggesting is let this matter go back before the deputy commissioner afresh and let him, my lords, redo the entire thing afresh, my lords.
Is there any power, is there any limitation to review?
Yes, my lord. There's no limitation, my lords.
There is
No limitation.
He can review any order.
My lords, that is what the laws, statute reads, my lords.
Just take.
May I
and
just,
give him.
may I just, my lords, may I just show, my lords, the prejudice? May I just show, my lords, prejudice, my lords? Page 283.
Prejudice within 2 weeks.
My lord, just served on Monday night, my lord.
My lords, may I say this, my lords? There's a delay application also that has been filed, my lords. Let that be condoned. Let the matter be posted for admission.
How much is the delay?
82 days, my lords.
That
That can be condoned, my lords. And I have genuine reasons also for my
Let's
lords.
say this is an application seeking condonation of 82 days
Lord.
delay in filing the appeal.
File
for the reason
objections.
state- Pardon?
File objections to.
For this condonation, this we will not agree with you. Okay? For the reasons stated in the affidavit, the delay in filing the appeal is condoned, application disposed of at the request of counsel for the respondent number
1 and 2, my lord.
1 and 2, comma, re-notify on, just give it after 3 weeks. In the meantime, counsel for the parties to file the written submissions. Along with the judgment, they want to, with the complete pleadings of the learner single judge are here,
Yes, my lords.
after 3 weeks immediately.
3-7.
Do. Please,
Next.
great. I'm grateful, my lords.
3-9.
We may have to sit after lunch. None for the parties. Mr. Gunjal, you are appearing? Yes.
These matters, my lord.
Yes.
So the two IAs were filed as section 151, my lords, and one was under 12 rule 6.
Ma'am, show us.
Yeah,
the
please, my lord, I went through certain research, my lord. Could it be taken on Monday? I will satisfy your lordships.
Now, what were the applications you had filed?
Please, my lord, I have filed the application.
And what were the
Please, my lord.
substantive suit? What was the substantive suit?
The respondent did rule out the jurisdiction, my lord, and also that arbitrator has exercised jurisdiction.
What is this AC? AC is what?
Please, my lord.
AC is a section 9 petition application.
Yes, my lord.
Huh?
In
No,
three
you
matters,
challenge the
authorized-
order passed under section 17.
That they have, I'll have to satisfy.
Yes.
I've given my explanation, but I thought let me further study it.
And what has he filed? What has he filed?
In MFA 3593.
But tell us one thing, Mr. Gunjal. These orders have been passed under section 17 application.
Section 17, section 151 was also filed.
Before the arbitrator.
Before the arbitrator.
Now, where is the remedy? Where is the remedy against section
Please, no,
17?
No, that is what I would like to satisfy. I went through certain judgments just now in the library. By Monday, this because 8 appeals are there, 5 are held to be maintainable.
You read 37.
Section 37. what was it?
That's right. 37, only granting or refusing to grant interim measure under 17. Okay.
Appealable orders, notwithstanding anything contained in any other of a time in force, an appeal shall let the following orders and no others to the court authorized by law to hear appeals of the original decrees passing the order. Then refusing to refer the arbitration. So in one way, I thought it should be filed with the civil court or not also, I thought.
That's right. You should go there.
By Monday, I'll clarify, my lord. I'll make
Okay.
myself satisfied, my lords.
Yes,
That's the reason.
do that. Look into it.
I got it, my lords.
At the request of Mr. Gunjal, re-notify on Monday.
Monday, my, that is,
Definition of the court. Definition of the court.
please, my lord.
Arbitration Act refers to.
Yeah, I got it, my lord. That is 2, 8 to 9 and 45, 47, 48.
Note it
Please, my
down,
lord.
all
8
those
matters
matters.
are there.
Which are the numbers? 2,
2, 5, 7, then 48, 49, 50, 51. Much.
his appearance would be there, Mr. Gunjal, all those.
But
We'll come back after.
it came to my mind, my lord, I started studying that.
5, 6.
It should be there only.
7, 8. 5 to 8. 5 to 8.
His name is there, no, ma'am.
My lord, I have filed a memo for my case to be heard at the senior with the chair by the senior justice in Court Hall 3. That is for Friday the 6th. That memo was to reach you yesterday. They have made a mistake. It will be coming this afternoon.
No, no, memo, you mentioned where? Where did you mention it?
I have filed a memo giving details to post my case on Friday in the afternoon.
We don't know that, you may.
That will reach you today, this afternoon. It will come there because they made a mistake. They should have sent it yesterday. Once you go through the memo, it will clarify everything, my lord.
Just one.
RP.
So it is not before us. Did you move before Court Hall 3?
I have moved, and now, in fact, I had been there just now, just as they got up. And since it is at your discretion, the file will come to you.
No, is it our jurisdiction? That will become. You have filed a memo, na? We will see it.
It's a bit intricate because from that, there are 2 more memos lying there which I have given copies. Your lordship can request for Friday afternoon.
We will see that. We will see that. Yes, ma'am.
Kindly have it on Monday.
5810. Just a renote at the request of counsel for the appellant. Adjourn to give a normal date, ma'am.
24/7.
Not possible. Next.
Serial number 52. 52.
See none for the appellant, none for the petitioner, adjourn to.
48. 53. Shri Hari Prasad.
My lord, appearing for the petitioner, my lord. In this matter, my lord, this honorable court directed me to file the recent survey sketch made by the ADLR and also along with the Lokayukta. I have filed that survey sketch, my lord. In the survey sketch, regarding that, I have filed an application. This honorable court already in the order sheet, order itself, directed me to produce. That I have produced, my lord. The sketch recently prepared clearly shows that in the buffer zone, within 30 meters, the respondent number 5 corporation allowed the respondent number 13 to construct the multi-story building apartments. Regarding that aspect, already the honorable court granted the stay also. Regarding that point, the today posted, my lord, I have produced that document. Service.
Who appears for the respondents?
Respondent number 4 and 5, my lords.
So what has to be done? This shows
And,
the file. What is the interim order you have?
Interim order not to stop the further construction.
That's
That is
continuing.
continuing from 1 year.
Now there is a fact, before looking into the regulation, he claims that the buffer zone should have been left, including the road which is abutting the tank. That's what my learned friend has said. Now, for a moment, I request my lords to kindly see the regulation number 4.12 of the master plan 2000.
No, what have you filed?
I have heard several.
No, he.
I have filed the sketch, recent sketch made
We
by
have
the
seen-
ADLR and also Lokayukta.
What he claims is, one sketch has been produced before the Karnataka Lokayukta in complaints of some notice. In fact, that is not the sketch that is prepared voluntarily or in process of the direction of the song. Now, my lord may kindly appreciate the short prospectus of the petition would be, what is the buffer zone that is to be there? For a moment, I take my lord to the regulation 4.12. 2, 3. Now the contention of the learned friend is, there is a tank. It is not in dispute. There is a road abutting the tank, which is a tank which is in existence from time immemorial. I have produced the village map 1904. It shows that in between my
Where is the construction coming?
construction is my property after the buffer.
What is the buffer zone?
In case of water bodies, I am reading at 4.12.2 in that point 3. They prescribe the buffer zones for various
30 meters.
in case of water bodies, permitted to
Yes.
water bodies, a 30-meter buffer, no development zone is to be maintained around the lake as per the revenue records with the excellent activities associated with lake and buffer will be taken into consideration. So this is the no construction zone which is request to be maintained, which I have maintained. So for a moment, my lord may kindly peruse the documents in this regard. My lord may tell you along with my statement of objections. Before sanction of the plan, the planning authority, VDA has been consulted by the local body, VDMP, as to what is the buffer zone for this particular area. Now the VDA has written
to the deputy commissioners intimating me that the buffer, there is a tank and the tank has been already fenced and it is beyond that it is classified residential use and there is no impediment of that. Now the tank, my lord, if you use the photograph, my lords, it will be very convenient for my lords. Village map, I am just taking my lords to the village map, which is at annexure R4 at page number 28.
Of what?
My statement of objections. My statement of objections. Page number 28. Now, this is the village map. My lord would see the extreme western side, that is the tank, and in between there is a road which leads to Sarakige, that is mentioned as Sarakige or Nakal, towards north. My lord would get from Puttenalli, there is a road leading to Sarakige. That is the road. Now, the CDK has been prepared by showing this particular area, and I have produced, my lord, the sector master plan along with the statement of objections at page number 76, my lord. Page number 76, my lord, may kindly peruse in yellow color. Now, Puttenalli Kere. This is the tank which my lord council is. Now, in between this Puttenalli tank and my property on the eastern side of this 24, my lord would find a road. Then after that, next annexure may be kindly perused. This is the Google map, which also shows there is a road in between my property. My property is on the eastern side. There is a small one area which is shown in triangular piece. Now, in between after this road, my property is situated. Now the photograph may be kindly perused. Next page.
Where is your property?
My property in the village map, I will say survey number 25 is visible. That is my property. In between my property and road, there is survey number 25 which is situated. Now my lord had kindly come to photographs. At page number 78, my lord would find the building which is in question. After that, there is buffer zone left. After that, there is road. And after that, next page, you may kindly 79 may be kindly finished. There is a tank boundary. Now, in between my property and the tank boundary, there is a buffer zone of more than 30 meters which has been already left, as per the sanction plan which I have produced before me. Now, what he claims is, this particular road which is in existence also falls within the survey number of this particular tank.
What the road?
Yes.
The road also form
He says
Part of the lake, part of the lake.
forms part of the buffer zone.
Buffer zone.
Yes, it is buffer zone. It is not denied. What he claims, buffer zone is to be taken after this road. That is the contention.
And the what is the relevance of 30 meters?
30 meters is from the water body, from the edge of the water.
No, so that 30 meters would be part of the buffer zone.
30 meters will be part of the buffer zone. Buffer zone is already there.
Abating that.
Falls in the road as well as in my property also.
Abating that.
The water body is there.
Regulation is very clear.
Here, this road. He says beyond that door means. He says that here it is 30. He says that on the edge it is 10 meters. So the issue is only this.
My lord, the road is a part of the outer body, my lord.
My lord,
Part of
may come to.
No, 1 minute. Whether the 30 meters run from the water body or from the road, from the edge of the,
From
from
the
the edge of the road. According to you, from the edge of the road.
edge of the.
That's the issue.
No,
He has clarified
And
that it is from the edge of the water body because regulation is shown that from the water body 30 meters is the buffer zone.
and my lord, it's a downstreams, downstreams.
Sanction plan which
And,
demarcates the same.
And the super,
Lake Bomri, after that road, then the buffer zone, whatever 7.93 meters which is coming in my area. After that, the building plan has been sanctioned. In my area also this.
You see the three.
my lord, the Supreme Court held, my lord, downstreams, 100 meters, it cannot be any this thing.
Who appears for the local body?
Corporation, BBMP, they have not filed the statement. They cleverly avoided 1 year, they have not filed statement.
My lords, we are filing the wakalat today for our
You appear for whom?
BBMP.
Why
For
have you
SH
not
Prashant.
filed the counter till now?
My lord, we had not filed the wakalat till now. We were getting the confirmation on that.
But
We are
there was a
filing the-
counsel earlier.
My lords, I'm not aware of that.
When will you file?
Today only, my lords.
No, Wakala, what about the
Scheduled
objections?
1 week, my lord.
Specific
File it.
direction given, my lord, kindly see the order sheet.
She says so, she will file it.
Oh.
Just say that so and so appears for BBMP.
Yes, my lords, R5.
Respondent number 5 states that she shall file wakalat. Who is the counsel otherwise?
SH Prashant, my lord.
Which SH Prashant is the counsel for BBMP, who shall file his wakalat during the course of the day. She also assures the court that objection shall be filed within 1 week
Yes, my lord.
from today, noting the said statement, granting 2 weeks to the petitioner to file rejoinder affidavit, re-notify this petition on. Let's give it in July. Yeah, we'll give you in July.
7/7.
There is no interpretation, any judgments on this interpretation? You have also judgments on the interpretation.
Yes, Supreme Court is there, my lord.
Show us.
Supreme Court covered by Supreme Court judge. Supreme Court.
Any area which is already lost statistics.
We'll see. Thank you.
54, Sri Harish. 54.
Just run through.
Proxy for petitioners, my lord. There is a small income, we will see it. Not accommodation.
At the request of counsel for the petitioner adjourned to.
17/7. 55. 55, Sri Ramesh Chandra.
I appear for the petitioners, my lord. 2 persons have not been served because they have vacated. That's why I'm filing a memo. I have filed a application for paper publication. Now I came to know that they have already vacated. This is a small matter, my lord. Your lordship has decided against me in the case in a residential main, whether a commercial, that is the matter, my lord. Here, in my case, it was opposed. I was saying that it could be done. Now court has said no, in a residential main, no commercial activity could be done within that is the matter.
So how do you want to serve them?
No, that's why I'm deleting them.
Oh, you're deleting them?
My filing in.
Just say that learner counsel for the, Mr. Ramesh Chandra, learner counsel for the petitioner has filed a memo seeking deletion of respondent number 15 and 24. Just show us that. No? In view of the contents of the memo, the respondents 15 and 24, R15 and R24 are deleted from the memo of parties. Let amended memo of parties be filed within 2 weeks from today. List the petition.
Short part consideration. It's also covered.
Next. Just give a date, ma'am. No, and in view of the memo, in view of this order, the application being 1 of 24 has become infructuous and dismissed as such.
Yes.
That's publication.
Yes.
16/7. 56. Rule number 56.
Petitioners in this case.
Just list this petition for hearing on.
21/7.
But I'm filing an application for implementing in this matter.
You file an application, we will consider as and
May I
when
seek for a
listed.
shorter date in this matter, since
Yes, we will have it 21st of 7. Next.
57. Shri Naveen Chandra. 57.
Appearing to the appellant, my lords, I seek to short accommodation in this matter, my lords.
At the request of counsel for the appellant. Adjourn to
10/7. 58 adjourn. 59. 59. Shri Balraj.
none for the petitioner. Adjourn to
68. 60.
Let's make this submission. The very same submission was made on the first date. Notice was accepted by them. Advance copy was served upon them, and they've been representing in all the dates. My only request is that they are precipitating the matter before the trial court.
just show the file, man.
I will take my lords to the entire petition, the order, my lords. Few of the respondents were deleted, my lords, and the respondent number 1 to
Now, what have you filed? Appeal under which provision?
I have been agreed with my lords.
Just give us CPC. Yes.
That's being agreed, my lords, under an application which the respondent had filed under order 1125, my lords. Having dismissed that, my lords, we have come before this court under section 30.
See order 43.
13(1)(e), my lords. That as against the interlocutory order, my lords, division bench of this court.
Which, what was the provision under which you filed the application?
My lords, the application was filed under order 1125. My lords.
No, how is the appeal maintainable?
That's the appeal is maintainable, my lords. It being, that's the same issue, my lords, came to be the adjudicated, my lords, in a connected matter, on a similar matter, my lords, by a coordinate bench. Where, my lords, an interlocutory application, my lords, came to be challenged before the court under section 13(1)(a).
This, you are on a commercial appeal governed by 13. That's right. It clearly stipulates under 13(1)(a) which are the provisions under which appeal would lie. Read that provision.
That's appeals from decree of commercial courts and commercial division, my lords. Any person aggrieved by the judgment or the order of the commercial court below the level of district judge may appeal to the commercial appellate court within a period of 60 days from the date of the judgment or order.
Read it further. Read it.
Yes. Any person aggrieved by the judgment or order of a commercial court at the level of district judge, excise coastal civil jurisdiction, or as the case may be, the commercial division of a high court may appeal to commercial.
It's simple. It's under order 43. It has to be anything which is under order 43.
That's respectfully, my lords, the coordinate bench of this court, my lords, decided by Anushka ma'am and Anant Ramnath Hegde, sir, have taken a view that, my lords, an interlocutory order, a commercial appeal under section 13(1)(e) is maintainable. I'm sorry, my lords, this issue was not raised by the registry nor by the bench, my lords, the earlier date. I didn't have the copy of the judgment. I may be allowed to produce the judgment. In any event, my lords, I may just persuade my lords to.
What does the Supreme Court say? All those appeals which are enumerated under 43, order 43 are only appealable.
That's
Otherwise, are we not rewriting
That's those judgments were considered in that judgment. But that's I would place the judgment on record. Which is that judgment?
Commercial appeal 56 of 2025.
Huh?
Commercial appeal 56 of 2025.
That's commercial appeal 56 of 2021. But that's the issues covered.
This provision, this is only applicable. Writing the old provisions.
Six of 25.
25.
Yes, yesterday the one answer mentioned.
Vikram Vinci.
Vikram, sorry. 25.
21.
He said 20. I'll check.
Everything you come in. Difficult.
That's I would be able to persuade Madats based on the judgment of the coordinate bench.
Sure.
In fact,
But you will start from Supreme Court.
Please, Madats, I would.
And I'm forgetting the name. And clearly, it's only all those appeal under 43 which would be maintainable. Unless there is an appeal under 37 of the Arbitration Act, all those things.
It's not the case in this matter.
It's not a case.
It's not a case.
Then,
I go down Madats.
so look into it. Prima facie, we are putting you to notice. Okay.
Let's make one request. My lords had issued, the matter had come up before my lords only on 27/1/2025. My lords had issued notice at that point of time.
You're right. So
Because
what?
I
We have.
understand the issue of maintainability can come at a later stage. That's a subsequent issue. The matter kept on moving, my lords.
It's all right. Is that a plea? We can say about this thing. We have now become clever. So
On
no,
that
let's.
day, the judgment was in not. I could not say anything.
See, it has to be read that way. Unless and until you show us some material, we'll keep that issue open. But 43 talks about order 11, rule 21. That's an order passed under that, and that's not your application.
May I request the court to have it tomorrow or day after minutes, so that I'll be in a position to.
Yeah. Come next week. We'll give you some time for you.
To have the judgments. I didn't get it together, sir.
Next week.
That's,
Just give it
9
next week.
Monday.
Yeah, Tuesday, Monday.
11/6.
I'm forgetting the name of the Supreme Court clearance.
Trial for it's on 12th.
The intent here only is shorten the litigation. That's the reason. And that's why more people is surprised. Commercial litigation that you should have 10-15 commercial costs to say that we have commercial costs.
That's may I request.
Commercial costs of the.
I requested to be happened on 10th, my lords. 10th of June.
They give it 10th.
Be ready.
Just say that so and so appears for R2, states that she shall file wakalat within 2 days.
61. Number 61.
Only 1 week.
Hmm?
Only 1 week.
At the request of appellant, adjourned to
17/7. 62.
Lordship, in this case, you see, before this court could issue notice, there is a complaint affidavit already filed by the accused. Lordship, the short question is, the judgment favors the complainant that he is entitled for the salary for the period he has worked after retirement date by the interim order of this honorable court. There was a direction that whatever the period he has worked after the date of superannuation, he is entitled to get the salary. Now the accused says that since he has taken pension, he is not entitled for the salary. That is the complaints affidavit filed before issuance of notice by the.
But what does Supreme Court say?
They are entitled, even this court, by the judgment says they are entitled for the salary. Pension is altogether a different aspect, and what he has worked is a different aspect.
See, tell us one thing. Now, how many benefits you would be getting for the same period? One is pension, the other one is the salary.
The salary part is for the period he has worked.
Very well, then we will record yours. You will get salary, but you will not take pension.
No, but if I am entitled for the full salary.
That's right.
That is my submission is, if I am entitled for the full salary, this court has given only the basic salary by the order, not the full salary. If I am entitled for the full salary, then I can't claim the pension. If I am entitled only to claim only the basic salary, then pension is different, and for the work what I have done is different. This cannot be clubbed.
See, when are you considered as a pensioner? The day after you attain superannuation.
Yes.
That's the pensioner.
Yes.
Now, what are you claiming as a pensioner? Are you entitled to salary?
By the judgment of this court and also the Supreme Court, I am entitled for the salary for the period which I have worked by the interim order.
Let's see the direction of the court.
The Lordship will.
See, come to page 13.
Page 13 is the judgment. Relevant portion is page 15.
Okay, now after this order, they have passed an order. After this court order,
They have not passed any order.
submitted a detailed report.
Yes, before passing of this judgment, there was an order. Your Lordship will get this in page.
No, after this court order, did they pass any order? Where is that?
That's with the complaint affidavit.
And what do you say in this?
Because we are standing in the same line as my Lordship expressed.
You are giving him pension?
It can't be a dual benefit. He should have not taken the benefit of the pension as such. Relevant portion, my Lordship will get it as page 10 of the compliance affidavit.
Retirement age is 60 years.
The issue was, the risk was this, my Lord. 60 years, the superannuation kicks in. But there were certain central institutions which had given the benefit up to 62 years. So many petitioners approached the Honorable Court and told, treat us in parity with those of the central government, similarly placed persons in the central government. So because of the interim directions, there were some petitioners who were continued till the attaining finality of
62.
the set list. But the set list ended telling that with regard to the state government, it could be only 60 years. Now, he accepts the superannuation at 60 years and takes the benefit from the date of superannuation. If he wanted the benefit as per the interim order, for that period, he should have not availed the pension is our stand before your Lordship.
But tell us one thing. When the issue was sub judice, between 60 and 62, he was working. He was working as a normal employee and you were paying him some amount, not the complete salary according to him. Now, 62 was rejected. Now, between 60 and 62, whatever is the salary he is entitled to as an employee, he would be entitled to because he has worked. He has put in his labor, everything.
But that would be subject to that period pension not being availed by him as such.
But there would be another issue. would you treat him as superannuated at 62 or 60?
We have treated him as superannuated
At 60.
Which he, without demo with regard to superannuation at 60, he has accepted the determined pension and is aware the same. He should have given a representation telling to the period in which I have worked, but by virtue of interim order, I should have got the salary, and when it ceased, my work ceased beyond that point. From that day, he should have determined the pension. That is not the stand.
Okay.
He
Now,
accepts the pension.
now just we want to know,
My lords.
he had availed the benefit of some salary between 60 to 62. He has availed?
No. No salary is being paid.
No, between 60 and 62 did
No
not,
salary is being paid.
you did not get any salary.
So this court, in the judgment while disposing, in 60 and 62, they have not got this salary.
See, he can argue this. He say, I have worked. If I had to superannuate at 60, even otherwise I would have got pension from 60. That in any case I am entitled to. But for this 2 years of service which I had put in, I should be paid. Getting the point? He has put in his labor, his efforts, his everything for 2 years. And he has worked for you. So you say, I am entitled to. If I have to be considered as a pensioner at 60 years, without working, I was entitled to pension. So what remuneration I am getting for those 2 years which I have worked?
In such a scenario, you would be entitled to the salary beyond the pension payable.
Minus the pension received for that period. The pension received. Salary. X would be salary for 2 years. Why is the pension he has received for those 2 years? For those 2 years. Pension. What he is entitled is X minus whatever salary you got, salary will be there. Suppose 10,000 rupees is salary. 10,000 rupees is entitled for that period. He has received 5,000 per month as well. That will be some that will
Now he is stopped because he has accepted the pension. He should have taken up a contention telling, I am not going to accept the pension. With regard to the period in which I have worked, for the extended period, pay me the full salary.
How much is the difference between pension and the salary? Well, surely at least logically think.
It would be more than the pension amount, that is undisputedly would be.
But naturally, it will be.
For example, if it is 1 lakh, pension would be 60,000. So with regard to the difference amount, he would have been entitled.
No, we are now putting it to you. Will he not be entitled to at least the difference of the amount?
That is what I am rephrasing and telling my lords. If the salary is 1 lakh for the extended period and we have paid the pension amount at 60,000, now for the balance amount of 40,000 is entitled to stand as. This is what I have claimed here, that 40,000.
So you are
I am claiming the same, my representative.
So both are agreeing with each other.
Agreeing
So-
in the sense there was a technical issue because of he accepting the pension amount. We didn't pay the salary with regard to the period in which he had worked because of the.
Right, but in.
For 2 years, pay the salary minus pension.
I'll verify, factually verifying the.
Minus pension, so that at least he will have the benefit of the, the services he has put in.
That is the service. Even in Supreme Court judgment, it went and actually.
What, you want to take instructions on this? Just say that we have heard the counsel for the parties to enable the counsel for the respondents take instructions as to whether the petitioner shall be entitled to the benefit of salary for the period beyond 60 years up till 62 years after adjusting the pensionary amount. After adjusting the pensionary amount. At his request, re-notify. So we let him take instructions. This is peculiar. That's what the Supreme Court says. You know, there are generally type of, on what basis he continued beyond 60 years?
Only the interim order of this, your lordship.
Thank you.
97, 63. Shri Nagaraj.
Ma'am? Files have not come up. 63, 64, 65, 63. But in any case, we will resume this. You didn't get. Because I say. 63, 64, 65, this 65, this. Yes.
11 days delay in filing.
Pardon?
11 days delay in filing.
Who appears for the respondents? Just show us the file. We'll condone the 11 days. Huh? 11 days will make a difference. Issue notice. So and so accept notice for, you appear for 1 to 4?
Please, my lord.
No, just see it also 5.
1 to 7, my lord.
7, 1 to 7. Let
8
notice
and
be
onwards, notice may have to go.
let notice be issued to the other respondents returnable on.
8, please.
58, 64, SB total, 64,
And this is a different file.
Number 4 was working as a contract employee in the appellant list, and he filed a writ petition seeking for regularization. The learned single judge allowed the writ petition following the order passed in WP 19344, which is at page 3.
How many years he had put in?
Well, he has worked more than 13 years.
13.
13 years. There are another connected writ
but there is a
appeals
delay.
also, and the learned single judge, which he has followed the order in allowing that writ petition. That writ appeal is also pending.
Which is that number?
That writ appeal 731 of 24.
731 or 24.
Is it before this bench?
It's
Is it before this bench?
731 of 24.
No, arising from the same impugned order.
Not arising of the same order, my lords, the order passed in that writ petition has been
Followed here.
in this writ petition. And that order is also being challenged, that is pending, my lords.
Just say that we have been informed by the learned counsel for the appellant that another writ appeal being 731 of 2024 arising from writ petition number 19344 of 2014. What about 49297?
That is also, that is a connected writ petition along with that.
Connected with that.
Petitions were clubbed and order was.
And 49297 2014, on which reliance was placed by the learned single judge in allowing the writ petitions from which the present appeal has been filed. Writ petitions. What about the other writ petitions? There is no appeal.
There were two, there are other appeals also, my lords, that have been, notice has been ordered.
For which date? See, then we say nothing. You file a memo, get it all tagged together. Just say at the request of counsel for the appellant, re-notify.
So that I will serve it.
Common judgment, and these are the. You can do it.
60.
Research of these other issues, they can correctly check the interviews which is common. That such registration. But what will he do? He cannot do that. You have to do it. You cannot the registry.
Just say that, cut that, ma'am. The present appeal has been filed from against an impugned order, common impugned order passed on 21st September 2023 in 5 writ petitions. This appeal lays a challenge to the order in writ petition number 3833 of 2021. Registry to give its report as to whether any other appeals have been filed.
Other appeals there are.
Which are the numbers?
What's that?
The learner counsel for the appellant submits that he shall give the details of all the writ appeals involving the identical issue pending consideration before this court on the next date of hearing.
Please.
Give the detail, we'll tag it.
Please. And notice may be ordered, so that also.
Additionally, the registry shall also give report as to whether any connected appeals and other appeals have been filed against the common judgment dated 21st September 2023.
There are around 12 writ appeals. Give order.
Interim order.
Please. Notice may be ordered, so that I'll serve a copy.
I'll take for 1 and 2, my lord.
Or is a private
Just say that issue. In the meantime, we deem it appropriate to issue notice in the appeal. In those also notice have gone?
Notice has been ordered in 3 writ appeals, still.
Issued, and he just said that he also states notice have been issued in some of the appeals.
3 writ appeals.
3 writ appeals. Issue notice. So and so accept notice for 1, 2 and 3.
1 and 2, my lord.
1 and 2.
1 and 2. Let notice be issued to 3, 4 and 3 and 4.
3 and 4.
Returnable on.
22/7. $65.
So answer appears for respondent number 1 state that he intends to file objections to the application file for seeking condonation of 317 days delay. Be filed within 3 weeks, rejoinder within 2 weeks, list on.
28/7. $66.
Please, my lord, I am appearing for the appellant in this case. Appellant here, my lord, due to some inconvenience, I could not move back post lunch to the Honorable High Court building. I have to be physically present. May I request for tomorrow, my lord? I am ready to go on with the case. Matter also requires consideration.
It may not be. Can be taken up anytime next week or thereafterwards.
We'll give
Tomorrow
you a
I
date
can-
in June.
Please,
Not possible,
because
we'll not be able to take up.
coming Monday, my lord, because the June month is the relevant period for this.
We will give you a convenient date.
Please.
Just say that re-notify these all 65, no?
66 minutes. Your lordship is now taking up 66.
Okay, 66, re-notify this for hearing in July. Just give it in July.
Please,
My
minutes.
lord, June month is the relevant period for liquor license renewal. So if
Pardon?
it is, June is the relevant period for liquor license renewal. So if it is taken up, my lord, before
First
the.
week or second week of July, it can be taken up. Minutes. So
No,
See,
but coming
it
week,
may
I'm
not be
ready.
possible.
What happened was morning I was physically present. Afternoon in front of because there was some disruption and we could not move back. That's why, my lord. Otherwise I would have physically present.
Just give it in last week.
Monday I will take my chance.
30th June,
Please, my
30th
lords.
of June.
Please.
67, 68 adjourned, 69, Srimati Vidyalata.
My lords, this is a public interest litigation where, my lords, the deputy commissioner has reserved a lake area, my lords, as burial grounds. So that has been challenged. The government were to make their say in the matter, my lords. Nothing has been done yet. Law prohibits, my lords, any activity in the lake area, my lords.
Who appears for the respondents?
The government appears, my lords. The government, it's all the government advocate.
Have you filed your objections? You file your objection. What about the others? Issue no. Do you appear for all five?
All of them.
The Conservation Development Authority also. See page 6. Page 6 of the appeal of the petition. You have State of Karnataka Deputy Commissioner, Assistant Commissioner, Tehsildar, and Karnataka Tank Conservation and Development Authority. Okay. I think you appear for 1 and 4. 1 to 4.
1 to 4, my lord.
So let this say that so and so is present for respondent 1 to 4. There is no presence for respondent number 5. In the interest of justice, we grant time to the aforesaid respondents to file their counter affidavits within 4 weeks, rejoinder 2 weeks, list on.
21/7,
Grateful, my lords.
70, Bhimaya.
My lord, I'm appearing for respondent 9 to 10, my lord, 9 to 19.
This is also connected with that earlier matter.
It is
My
not
lord,
connected,
It is
but
one new
similar.
matter.
Yes. No, that is different. This is different, man.
Different
Yes,
matter?
Yes.
My lord,
Please
may I
re-notify.
submit, my lord?
My lord,
This matter is,
state government has not filed
Sir,
objection till today.
You were to file objections?
We'll get filed.
Objections we file within 4 weeks, rejoinder 2 weeks. You
can
file
I have
another
the same
impediment
date, my
here.
lord? Yes, I'll file the objections, my lord. Can I request for 21/7, my lord?
1 minute, please. You are appearing for which respondent?
Respondent 10 to 19, my lord.
Okay, you file your objections.
Yes. Lord, may I seek for the same date, 21/7, my lord?
You appear for whom?
I'm for respondent number 1 to
4.
4, my lord.
1 to 7.
1 to 4, na? 1 to 4 and 5 to 19. You appear for 5 to 19?
No, my lord, the 10 to 9.
My lord, I'm for 1 to 4, my lord.
Who appears for 5 to 9? But you can appear for this 5 to 9 also.
Yes, my lord. They are the officials.
They are the functionaries.
Very well.
Deputy conservator, assistant conservator, range forest officer.
Yes, yes.
I'll take
Also,
notice, ma'am. I'll
1
take
to
note.
9 he appears, 10 to
Yes.
19 he appears, counter affidavit 4 weeks, rejoinder 2 weeks.
22/7,
Watch.
My lord, can I have the date on 21 itself, my lord?
Pardon?
Can I have the date on 21/7, my lord?
Just one, just take it.
21/7,
21/7.
Yes, yes.
Obliged.
Hold on.
71, serial number 71,
Green page.
None for the petitioner, adjourned to.
24/7, 72,
72, I represent the
Yes, Mr.
petitioner's
Kalenda.
counsel. My lord, the petitioner is, my lord,
Is it to be argued?
that's on him. I know, my
Requires
lord,
some-
if I can say, I know the state will always say it has to be argued. It's an easy way out for them. My lord, if your lordship sees the petition is by my lords, Kudremu Kairanur Limited, which is a,
What was the file, ma'am?
it's a government of India enterprise, my lords, wholly owned, my lords, by the Ministry of Finance. So, my lords, if your lordship recollects, Kudremukh had a mining lease in Kudremukh area, the entire Kudremukh area in Western Ghats, my lords. We had a mining lease, central government enterprise. Ultimately, my lords, the lease was being renewed and in a public interest litigation in Godavarman case, the mining lease was directed to be stopped pursuant to directions of the Supreme Court and the CEC, my lords, where they came out, the CEC was directed to come out with a rehabilitation scheme. We had to shut down the operations. A date was given, 2006, to shut down. We had our own revenue lands also. That's the government of India was owning it, about 1,000 hectares. CEC was directed to come out with a scheme where they said entire revenue land to be handed over to the state government, so that the state government will then take it towards compensatory afforestation and raise plantations over that. Revenue buildings were the quarters. These leases were in existence from 1959 onwards from NMDC. That, my lord, the CEC came out with a plan saying that whatever buildings are there, there is a slurry underground pipeline from Kudremukh up to Mangalore, my lords, where there is a pellet plant established by the central government, Government of India enterprise. For that, my lords, what happens in iron ore mining, there used to be slurry and transportation to underground pipeline of 59 kilometers. In 1978, it was laid, so that the iron ore is converted into pellets and exported. It's a 100% export. Ultimately, operations came to be closed. Then, my lord, CEC came out with a scheme that certain buildings I can retain in Kudremukh area, only for ensuring that there is a dam built, my lords, which is known as a Lakya Dam, to ensure that water levels are there and the slurry pipeline is still operational. Because now there is no iron ore movement, there is movement of water. That slurry pipeline takes water to the pellet plant. So certain buildings, so that I keep my maintenance staff. And at book value of those buildings, some buildings only. Now, the book value of buildings was decided to be 25 lakhs in total. Anyway, that is going on. Now, since that lease came to be closed, I did not have any mining lease in state of Karnataka, which is most rich in iron ore. The Government of India, on a recommendation by the state government, my lords, under the MMDR Act, that's the Mines and Minerals Development Act, reserved an area of about 400 hectares, 400 and odd hectares in Bellary district for my purpose, central government enterprise in forest area, under, my lords, the 17 of the MMDR. Pursuant to that, my lords, it is a forest area. This area which is being given to me is a forest area. Under Section 2 of the Forest Conservation Act, my lords, I had to take clearance from the MOEF, that's the Ministry of Environment Forest. Proposal went from the state government to the central government. MOEF considered it and granted first stage clearance. There are two stages in which the first stage was given subject to certain conditions, which I had to comply. That's the user agency had to comply and they had to recommend. That's payment of NPV and other things so far as the present lease area is concerned. I complied with it. State government sent the recommendation. In fact, they said this lease has to be given to the central government enterprise because we earn revenue and it's a government. Ultimately, it's a wholly owned government enterprise, PSU. The MOEF took it and granted a Section 2 approval. That's a final approval, my lords. For a moment, if your lordship kindly come to page 58. On 16th December 2022, if your lordship gets that, my lords. Running page 58. The lordship gets that, my lord. Now, please come to para 2 in that bottom, my lords. It starts with in this connection, your lordship gets it. In this connection, I am directed to say that on a basis of compliance report furnished by the Government of Karnataka, while letter dated 1st October 2022, final approval stage 2 approval of the central government is hereby granted under Section 2 of the Forest Conservation Act 1980 for diversion of 401.5761 hectares, 388 hectares of forest land in Swamimalai Block Forest, Sandur Taluk, Bellary District for iron ore and manganese ore mining in Devagiri Hill Range in favor of KIOCL, formerly Kudremukh Iron Ore Company, Bangalore, subject to following conditions. Now, please turn over. Your lordship should get A. Please see what it says. Conditions which need to be complied prior to handing over of the forest land in user agency by the state government. Part B, please see in that very same page at 15. Conditions which need to be complied after handing over of forest land to the user agency by the state government. So FAC, that's the Forest Advisory Committee, and the central government said, these conditions under A, they have to comply before you hand over the forest land to them. So far as conditions under column B, they have to comply after you hand over the forest land. After getting this section 2 final approval, the state government did in fact execute the mining lease in my favor, which your lordships will get at page 34 in 2023 April, my lords. So mining lease deed, after payment of about 350 crores, my lords, I had to take, my lords, approval from the finance ministry, and then, my lords, we paid the stamp duty. NPV is paid almost about 200 or 300 crores, which is already paid towards this lease. Now, my lords, the government passed an order, government order, which your lordships should get now at page 19, Annexure A. That's dated 11/4/2023, Annexure A, at page 19, my lords. The government order, your lordships would get 20. That is the record about the FAC approvals, lease being granted. Then they reiterate what are the conditions imposed, which your lordships would get at page 20. That's for the purpose of handing over the forest land, my lords.
Reiteration of what has been said.
What the central government. In that, my lords, I did not show, but here I can show the condition. Please come to page 22. 22. From 21, part B starts, my lords. The crux of the matter is only this, Roman 8 at page 22. The forest department, your lordship gets it, shall ensure the user agency must do the needful as per the Honorable Supreme Court directions and follow the instructions and recommendations of the CEC, and so also take required approval in a time-bound manner for the regularization of the violations in the Kudremukh Forest and National Park. It would be obligatory on the Forest Department and UA to get the regularization of the violation of the FC Act in the matter is done in time. The Forest Department shall also ensure non-binding conditions laid down by the FAC in the matter. So this condition, that's, my lords, what I said, my mining lease was closed there, and CEC has laid down certain particulars what I should do, which we have already applied for that. That's where I was supposed to apply for a post facto approval for the dam, the submersion zone, my lord. Forest got submerged because of the construction of the dam. That, my lords, according to us, is 280 hectares. We had filed an application in 1994 saying it is 340 hectares, seeking section 2 clearance. But my mining lease itself got closed in 2006. So after that, my lords, the MOEF had asked us to file it under an online system. So we have asked for 280, that is still pending. For the slurry pipeline, CEC and the state government insisted we should apply for section 2 clearance underground. We have applied, that is pending. Handing over the lands, we have complied with our condition, they have to take it. Now handing over of buildings, my lords, the state government and the CEC says 25 lakhs book value you take, hand over the buildings. State government says, I will not pay the book value. Now I can't do anything because that's a recommendation of the CEC. Supreme Court said whatever CEC says, you do it. And as a central government, I can't do anything. Now this condition 8, my lords, pertains to the violations in that lease. MOEF, with open eyes, the Forest Advisory Committee, everyone being aware of it, that it's a central government enterprise, said this condition, whichever is remaining relating to the regularization of violations of that can be done after you hand over the land to them. That's because, my lords, I have a pellet plant where I have employed about 900 people. Now it is virtually, I have to shut it down. I have already retrenched some people. I have to shut it down. I have paid 600 crores. That's public money. It is only going from here to another thing.
But these condition, this 8th condition is being insisted upon.
I am 8th condition. Now the state says, somehow I have lost. After all this is done, my lords, they have done everything they recommended. They said, I am good, everything. All of a sudden now, my lords, when I go to them saying, please execute the lease deed pursuant to your own government order, they have to execute a lease deed, forest lease agreement, which actually is not contemplated under FC Act, but they insist we have no issues. And hand over the forest land, because under the MMDR Act, if I don't start mining operations within 2 years, my lords, from the date a lease deed is executed, it stands lapsed. Government can extend it by 1 year, they have done it. But today now the state government all of a sudden says, I have lost trust in you. Till you comply with the conditions of regularization of that lease, I will not hand over the forest. So
how is that relevant for this?
Exactly. That is my limited prayer. You please, Lord, after all, I am a central. I am not a private player in this field. I am a fully owned central government public state undertaking. Now, my lords, I am only saying, you please execute the forest lease agreement in my favor. And if you are agreed by this condition by MOEF, FAC, you should either go to CEC or you should challenge that condition. MOEF is the ultimate authority under the Forest Conservation Act. They have imposed this, saying that whatever you have grievances regarding that can be taken care. First, you execute the lease deed or hand over the forest land to them. Today, state says, I will not hand over the forest land. That is why we have approached the court. My urgency is this. Now, my lords, I have given the list of dates which your lordships should get at page 65, running page 65. In that, if your lordship sees serial number 17 at page 66, the Public Investment Board under the Ministry of Finance is now asking, I have given you, lords, they have allotted public funds of 800 crores. Today, my capital is stuck. Plant is getting, I'll have to virtually close down the plant because for me, iron ore is the main requirement for running the plant. Private players are mining and selling the iron ore. But my lords, I can't buy it at an open price because it will not be viable for me. And I'm a 100% export oriented unit. I'm a mini Ratna enterprise in the country. And I have to face this problem that state government says I've lost trust in. That too in the writ petition. Otherwise, they have not even told me anything because they did not execute the forest lease agreement and did not hand over the forest land to me. I have come before this court. Oh, that condition, please see the prayer in my writ. Whatever violations pertaining to that lease, my lords, if I don't do it, I will be committing contempt. Somebody has to move the contempt before the Supreme Court, or somebody has to move CEC. Ultimately, CEC is the ultimate authority for that. Now, I am saying I am doing everything. If necessary, I will do it later. If I don't do it, you then take action against me after you hand over. That is the hurry in which we are placed today, my lords, because everybody is on my head saying that you either retrench people. I am already starting to retrench people because I can't pay. Workers are lying idle. Money, I have to pay them salaries for the pellet whom I have employed in the pellet plant. In fact, they had also sent the forest lease agreement draft. We approve. We said we are happy with it. We will go ahead. We do not know. After that, there is a change of stance. And the central government enterprise can't be handled in this manner with great respect.
Was this not, deliberated at the highest level also?
Lords, it was all done. There is some ego battle. I cannot say it. I cannot express it. We do not know what has gone wrong. Lords, ultimately, if your lordship, if they produce the records where they have sent recommendations, I can have a letter, I can show it to your lordships, where they say, state, I will have to, my lords, once I start mining, per year, I'll have to pay about 200 to 250 crores as royalty, apart from value of ore. They themselves said it is the best. Please do that. It's a central government enterprise. Ultimately, it's public money. Nobody is going to make money. It's a wholly owned central government enterprise. All of a sudden, we are stuck. That's why I'm saying, since Section 2 clearance is there, I should be allowed to work. Otherwise, you hand over the forest land. You can't
file the affidavit after the order of this court on.
Yes, they have filed. We have filed, my lords. We have filed our rejoinder. We have given every documents. All that is in relation to the other mining lease. What I am trying to say is that is all later.
We'll have it in the last week of June, Mr. See, it will be difficult for bench. That's
at least, my lord, my problem is this. We wanted an interim order at least. Since every clearance I have clearance under MOA.
Just 1 minute. Just have it after 20th any day.
23rd June.
No? Just say that, re-notify on 27th June. You file everything, Mr. Panendra, all the, the Supreme Court judgments in the.
No, it's all that is on record. It's all filed.
All filed.
It's all filed. Everything. Lords, can I request a little earlier date, my lords?
Arguments. on 27th of June.
Yes.
Okay.
Would it be a little earlier, my lords, one
Very
minute?
well. Have it on 22nd, 21st, 22nd.
Please.
23/6.
23/6. Thank you.
Lords, arguments are consideration of interim. Otherwise, it will go to
Said
final
argument.
hearing.
We have
No,
said argument.
Has to be
what happens is
disposed of.
here, my lord, sometimes when your lordship mention as arguments, the registry will post it in final hearing. Then, my lord, what happens is then it will never be either on the.
We will rephrase this. List
Please,
on
sorry.
23rd 6 for hearing. That would be fine.
Hearing, my lords, I would say consideration of arguments are.
For final hearing.
Lords,
That would be a more appropriate.
No, my lords, then it will never.
I have already filed my
For
statement of
consideration of interim prayer, your lordship
objection.
may
No,
say.
no, I have filed my statement of objection.
That's okay. Because it can reach, otherwise, my lords, hearing will not reach.
Has to
What
be
is the
heard. finally.
terminology you want us to use?
My lords, consideration of
Hearing,
interim.
my lord. My submission would
I
be-
don't know.
Why not the whole petition be heard?
My lords, at that stage, I don't mind, my lords, but if it is posted as hearing with great respect.
Very well. We'll say list on 23/6.
Very
That's
well.
enough?
Yes, my lord.
That's it. Okay.
73.
We might have to file, we may have to file statement of objections in this matter, my lord.
There was an earlier interim order passed by this honorable court. May I just draw lordship's attention to the earlier order passed by this honorable court.
What is this? This need to be heard?
Lords, it can be heard, but in the meanwhile, but now in violation of the earlier order passed by this honorable court, they have stopped the mining lease and they have asked us to surrender the iron ore which we have already extracted. The state government requires to be restrained. This is in teeth of the order passed by this honorable court. May I request lordships to kindly see the order dated 24/12/2024. May I request lordships to kindly see. No, not this map. No, not this. Where is the forest clearance? Sorry, my lord. The order is dated 24. Yes, correct. In that, my lord, lordships may kindly see paragraph 3, 24. Lords, kindly permit me to read from para 2. My lord. Petitioner is aggrieved by the demand notice dated 26/9/2024, which is the demand for a compensatory aforestation fee in a sum of rupees so and so. Sri so and so learned senior counsel for the petitioner, relying upon the Government of India order dated so and so, submits that the petitioner who has already paid the compensatory aforestation fee in the year 2005 would only be liable to pay net present value that the petitioner has paid even this value. But if there are to be any further demands, the petitioner will pay the same. But there cannot be a demand for compensatory aforestation fee, and this demand is without jurisdiction. Now, let's kindly see the next paragraph. In the light of the afore submissions, the interim order is granted, staying the demand as per Annexure A, subject to the petitioner filing an undertaking through its duly authorized representative with the registry by the next date of hearing to pay the amount in demand in the event the petitioner fails in the writ petition. Now, kindly see the last paragraph. The first respondent is also directed to consider the petitioner's request for forest clearance in the light of the interim order now granted and place on record its stand for further orders. After this order, now without reference to this order of this honorable court, they reject my forest clearance application. They don't consider it. Kindly see that order, which is now I have produced before your lordships along with the IA. We are seeking, let them not proceed further in accordance. This is has a disastrous effect on a going mining lease. That IA we have filed. Madam, IA copies. IA copy. Has it been put up? 3/6/2025. An application has been filed for a direction. Third June, what we have filed. Kindly see the last, the impugned now order at page 20. 21 is the operative portion. Page 20, it starts, lordships may skip that preamble. 21, lordships may kindly see. The government of India, so and so, and the government of Karnataka has accorded approval for forest clearance under the provision of section 2 of the Forest Conservation Act, dated 8/8/2005, respectively for diversion of 53.20 hectares. They give the details notes. In favor of Mrs. Nadeem Minerals Private Limited, MIN number 2526, for a lease period shall be for 20 years or co-terminus with the current lease granted under MMRD Act 1957 by the Commerce and Industries Department, whichever is earlier. Thus, as the deemed extension of forest clearance is not granted to this mine by the competent authority till date, this forest clearance is valid for 20 years with effect from 27/5/2025. That is valid up to 26/5/2025. Therefore, you are requested to stop all mining related activities in leased forest area of 53.206 hectares on the date of expiry of the working permission, that is on 26/5/2000. Take custody of the leased forest of so and so, so and so. Now, the premise on which they proceed is, our lease ended on 26/5, originally 26/5/2025. Therefore, the forest clearance also expired with that. But section 15 amendment, it has been extended till 2057, and the rules provide that co-terminus with that extension, forest clearance also gets extended. That is the position. And before this honorable court, on an earlier occasion, they said they had not paid compensatory afforestation fee. We are not going to clear it. This court directed them to do so. Now, this is the order they have passed. This is patently on the face that it runs contrary to Rule 7. But may I request Lordships to kindly permit me to take Lordships to Rule 7.4 minutes of these this newly framed rules. Copy. Rule 7.4.
But tell us one thing, this 21, the first two lines says Karnataka and New Delhi has accorded approval for forest clearance.
Correct.
That's right.
Correct.
And so there is a forest clearance.
There was a clearance earlier.
Now, if you see the bold portion in the same paragraph, co-terminus with the current lease granted to MMRD by the Commerce, thus as deemed extension of forest clearance is not granted to the mine. Now, what is the difficulty in not granting the extension?
No, it's not necessary in view of this. What happened was the 2015 Lordships are aware, MMRD Act came to be amended, wherein all mining leases which were originally granted for 20 years were extended by 50 years. The question was, forest clearance was available to those mining leases for a period of 20 years. What should happen to the rest of the period? Then Rule 7.4, this is the rule point, said that automatically madam.
So it's an automatic extension.
Automatic extension.
No further clearance.
No further clearance is required. 7.4. Madam, just now. 7.4. Position. 7.4 watches. 2 copies.
Just read it.
Please. Validity of approval granted under the Vana Samrakshana Evam Samavardhana Adhiniyam 1980.
The initial clearance was under this.
Yes, correct. That forest conservation is a Hindi word. Forest conservation and 1980 Act. In case of existing mining leases where approval under section 2 of the Vana so and so Adhiniyam for the entire forest land in mining lease has been obtained before 1/4/2015, the validity of approval granted under the Adhiniyam is deemed to have been extended for a period co-terminus with the validity of mining leases granted in accordance with the provisions of the MMDR Act.
Once beyond 20 renewal is till 50 years.
Yes, 50 years. So obviously, this also gets extended. It does not make any sense at all. The state government concerned may extend the validity of approvals granted under the Adhiniyam to the government companies for mining under the so and so to make it co-terminate. So and so, which will not be relevant. Therefore, it goes section 15. Kindly see section 8A subsection 2 of the Act.
Just show us MMRD.
MMRD Act 1957.
We may have to file objection, my lord. The application has been filed.
Let them
yesterday,
file
my lord.
objection, but they can't
Even
do
the-
these things.
no,
Going
even the-
mining leases for last 25 years I've been mining.
Lord,
Suddenly they say you stop mining and I will take over all the entire mining. That is something without notice, without anything.
My lord, the
When was the mining stop? 26th.
No, we are continuing, Lord. In view of this, it has been continued.
my lord, this
They have
application
not
is,
taken any action pursuant to this.
Pursuant to this, therefore, we have moved your lordship
Lord,
now.
this application is filed yesterday, my lord.
Section
It would take a
8A
week's
sub-
time to file my objection, my lord.
But
Even
let
for the
my
main
learned
matter,
friend
the
take time,
objections
Lord.
are
I have
ready,
no
my lord.
objection. But kindly see the last word. Despite, look at the way they have worded it, my lords. They have said that we want to take over your mining lease and all the iron ore which is available. Take custody of the forest.
But tell us one thing, they have not taken any action after this.
No, let my learned friend make a statement that they will not take any.
We will respond to the application, my lord, to grant us a week's.
So let him make a statement. Not kindly see the tenor of that order.
What is the basis of your apprehension?
No, that order itself, not. Therefore, you are hereby directed to stop all mining related activities in leased forest area of so and so on the date of expiry of the working permission on 26/5/2025. Take custody of the leased forest area of so and so, so and so.
How many days have gone by thereafter?
26/5 means we are 3rd June. No,
So for next 12 days, they did not.
no,
take
Lord,
any
if
action.
today, Lord, unless my learned friend makes a statement.
My lord, to
or
make
lordship-
a
one second,
statement,
one
my
second,
lord,
sir,
I
let
need
me
to
complete.
secure instruction, my lord.
No, I will be, Lord, in violation of this order. Lordship may kindly appreciate. Either, my lord, let him make a statement or my lordship may pass an
You
interim.
filed an application, he is seeking
I
time.
have to respond, my lord.
But I have no objection for him to.
You file it in 1 week.
Please, my lord, to the application, I will file my response in a
Yeah,
week's time.
but the only thing possibly you have to answer is this, what he has relied upon, this 7,
Very well.
rule 7.
Please.
Just say that this is an application
Next
filed by the petitioner.
What is this? The huh?
Filed with the following prayer. Our attention has been drawn to page 20, Annex AA of this application. More specifically, page 21, the last paragraph thereof reads as under. First of issue notice, so and so accept notice for 1, 2, 3.
He appears, they're already on record.
All, no, except 4, except 5.
Except 5.
You 5. You are for 5.
Yes.
So and so accept notice for 5.
They are already there. They are already there. They are already there.
No, this is in the
Please,
application.
please.
No, but tell us one thing, they have no role.
The government of India has no.
The learner senior counsel for the appellants fairly states that this application is primarily directed against respondents 1 to 4. The counsel for the respondents 1 to 4 seeks and is allowed a week's time to file reply to the application, re-notify on. Just give it after 1 week.
16/6.
Can it be next week if it is convenient? If it's only a request is
After 1 week, just give it on Friday next.
13th,
13/6.
please.
74.
Yes, Mr. Nair.
My lord, I appear for the appellant in this matter, my lord. My lord, the appellant is a society that is registered.
What has to be done in this?
There's a very, very short legal issue, my lord. The issue is, my lords, whether the district registrar, after my lords having approved the bylaws and change of name of the society, does he have the power to review it? My lord, the power of review, my lord, must be specifically conferred by the statute, which in this case has not been done. And therefore, my lords, the only issue is therefore when he has reviewed it and he has therefore, my lords, recalled and cancelled his previous, but that is consistent with the provisions.
The nature of power that is exercised, a quasi judicial or an administrative.
It is quasi judicial, my lords, because in fact what has happened is an application was filed by respondent number 2 saying that, my lords, this name change should not be allowed, and then he carries out an inquiry. That's a quasi judicial power, and then, my lords, he proceeds to cancel our change in name. My lords, that respectfully, my lords, we'd say is covered by a judgment of this honorable court. That issue, unfortunately, my lord, has not even been considered by the single judge. My lord, there are two aspects. One is, does the district registrar have jurisdiction? Secondly, if he has jurisdiction, there can be an appeal or a review on the correctness of how he's exercised that power. The single judge only considers the second issue without considering the jurisdictional issue, which, my lord, goes to the root of this matter.
What is the name you want to change to?
My lord, the name that has been approved, my lord, is the Kannada Film Chamber of Commerce, which was approved. The previous name, my lords, our name was Karnataka Dubbing Film Chamber of Commerce. So, my lords, the dubbing has been removed and Karnataka was changed to Kannada. In fact, my lords, this matter will have to be heard. My lords, only one request, my lords, which I could make to this honorable court. My lord, from 2017, when the writ petition was filed, till 2025, when it was disposed of, we had the benefit of an interim order, my lords, before the honorable single judge. But if that may be continued, this matter can be taken up.
What does it say? It protects your the
yes, my
new
lord, status quo will be maintained.
What are you using as today? Kannada Film?
Yes, my lords, Kannada Film Chamber of Commerce.
Is being objected to?
Well, it's the state, and well, it's
who will be objecting?
Well, it's respondent number 2. Is the private respondent.
Oh,
that's
is he appearing today?
They've been served, my lord. They were in fact they were on caveat.
Oh, there is not much of a difference. Kannada and Karnataka.
That's the difference.
What is the difference?
It's Kannada and Karnataka. Well, they are Karnataka Film Chamber of Commerce. I am Kannada Film Chamber of Commerce.
So see, Kannada may be specific to Kannada. And Karnataka encompasses maybe Hindi, everything, huh? We'll issue notice. Is notice issued to respondent number 2?
Yes, my lords. In fact, they were on caveat. My lords, we've served them. They are served. Respondent number 1 is also served.
Say that, ma'am, none for the respondent number 2, list for hearing on. Just give it in July.
And consideration of interim prayer.
Just list on this for consideration of interim relief.
DPO price.
Is there application there?
Application is there.
Rest, ma'am, run.
Grateful.
7, 75, 14%.
Just say none for the petitioner. Adjourn to. They do. You just say this. Petitioner is not present. Re-notify on.
37, 76, adjourn, 77.
Has to be argued.
Yes.
Well, I have to file a statement. in
Lord,
this,
they have taken sufficient time for filing objection because the working permission was granted for a limited period that would expire on 18/6/2025. Therefore, on the last 2 occasions, I insisted.
The petitioner has misled.
Let me make my submission.
My lord, my draft is ready. My lord may
No,
have it
this-
on 16th.
How much time?
My lord, 2 weeks.
Lord, further 2 weeks, it will expire. Their intention is to protect the erroneous officers.
My lord, he has paid penalty without registration.
Now, whatever it be, let them put it in writing.
He has
Ma'am,
misled this.
1 minute, please. The objections to the writ petition
Writ petition, my lord.
be filed on or before, just say Wednesday date. On or before next Wednesday, you file it.
11/6.
Oh,
My lord, that's too short for me, my lord.
Blood.
All right, ma'am, it's all right.
My lord may have it on the 16th, my lord.
We will have it on 16, no issue on that.
My lord, 16th.
Lord,
List on 16.
Lord,
You file it on Wednesday, we'll have it on
My
16.
lord, there's a slight personal inconvenience, my lord. 11th, I'm not.
Lord, on the, your last may kindly peruse the order sheet.
But
On the
not-
last
not
2
based-
occasions, I made this submission and my working permission is going to expire. And they have illegally seized 3 trucks and imposed penalty.
My lord, the trucks have been released, the
Ma'am,
amount has been
you,
paid.
whatever you are saying, you put it in black and
Lord,
white.
I'll put it, my lord, but not 11. My lord may take it on the 16th and file it on the 16th.
How many times the time was given?
Twice. My lord may
Why-
see the
why
year,
should we
my
give-
lord, 2025.
Ma'am, why should we give a third time? Tell us one thing.
My lord, usually it is 6 weeks time that is given as per the High
Depends
Court
upon,
interpretation.
see, depends upon surely what now, how would you meet this argument?
My lord, that he's paying.
1 minute, ma'am, you will listen to us. How would you meet this argument if 18.6 comes, it becomes infructuous? How do you answer that? Please tell us, it will not become infructuous, we'll give you time.
My
We'll
lord,
give you time.
My lord, may I make one submission? My lord, trucks were seized because they were illegally transporting the mineral.
We
my
will be
lord.
with you.
The penalty has been paid, trucks have been released. And
They have
we
been
seeking
released?
for refund of that
La-
amount.
1 minute, they have been released?
Yes, Mladi, for,
Then,
we,
1 minute, what is the then sanctity of 18 June?
my submission is, now they are successively seizing the vehicle for transportation of these minerals.
That we will look into it.
My lord, that is
Mla-
a new
mla-
course
mla-
of action.
Lord, during the
18 June, what is the sanctity?
18 June, before 18 June, I have to transport all the excavated minerals. They are seizing every now and then all the vehicles without assigning any reasons.
My lord, the 3 vehicles that he has complained
My lord,
of has been.
they are not spelling out. And the crux of the matter is, they are not assigning any reasons.
Fresh cause of action for which a separate writ petition has to be filed.
Just say this, counter affidavit be filed on or before 16th, list on 17th.
Let them serve the objection in advance so that I can.
Obviously, she will serve.
Everything we will take
One,
on, my lord.
1 minute, please. Let the same be filed by serving an advance copy on the learner counsel for the petitioner.
Obliged.
Adjourn 17th. Next.
78.
All incorrect.
Appear for petitioner.
Being attacked.
Yes.
The petitioners are the villages
Which
of.
is the number, ma'am?
78, sir.
I am for the petitioner, ma'am.
Yeah, we will have it some other day, please.
My lord, notice will have to.
We will see on the next date, re-notify.
Yes, I also sought for interim order, ma'am.
What is the issue?
Issue is, the petitioner, the villagers of the Karkuri village, and the Kaveri river is running at that limit of the village, village. And the Kaveri bridge is going to construct on that river. 70% of the building has been completed.
Please show us.
And to access that Kaveri bridge, there is a government land nearby that Kaveri bridge. 1 acre, 3 kuntas of land. Out of 1 acre, 3 kuntas, 8 kuntas required for accessing the bridge. That's all. Now the government is proposed to allot the site in that area to sightless person, my lord. Restricted only for 8 kuntas of land out of 1 acre, 3 kuntas. It is very access to the Kaveri bridge. Otherwise, it is very congested and it is not easy access to the bridge.
What is the prayer you have sought? What is the prayer?
Prayer is to
8
reserve
kuntas
8
of
kuntas.
land.
To reserve 8 kuntas of land out of 1 acre, 3 kuntas in surrender number 24 of the.
But are they claiming this land?
Not claiming, only for the purpose of road, public road.
Oh, that's right. They are acquiring it.
No, that government is proposed to allot a site in that area to sightless persons.
To whom?
Government, sightless persons.
To the?
Sightless persons, my lord. Landless persons.
Okay. So what is your right on this land?
Absolutely, I have no personal right in my land.
So for what purpose you have filed this?
To access that Kaveri bridge, it is, if suppose the entire land of 1 acre, 3 kuntas has been allotted to sightless persons, now it is very congested and it become very unable to access that bridge. Only for extent of only for 8 kuntas.
What do you say?
My lord, notice has to go. My
That's
lord.
right, we have heard you on that. You file your response.
Yes. My lord, I take notice for respondents 1 to 3. Notice will have to go to respondent number 4.
Issue notice, so and so accept notice for 1 to 3, let notice be issued to 4. Returnable on.
Till then,
No, till then. 75% you say the construction is over.
the construction only Kaveri,
You don't take that. Why you are accepting?
because there is a, suppose if the entire land is granted to sightless person.
I saw that representation which you have given.
Yes, my lord.
You are also part of it. Isn't it?
No, I am not a party to the representation.
Okay.
There is a Annexure A, my lord.
Annexure B.
Annexure A, B and C are the representations.
B ದಲ್ಲಿ ನೀವು ಇದ್ದೀರಾ ಇಲ್ಲ?
ಇಲ್ಲ B ನಲ್ಲಿ ಇಲ್ಲ ಸರ್. ಇಲ್ಲ ವಿಲೇಜರ್ಸ್ ಬೆಳೆಗಳು ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. It is inconvenient. Suppose the entire land of 1 acre 8 kunta has been allotted to sightless person, then it is very inconvenient to access the bridge.
What is your locus?
Locus is a public spirited person, because I.
Are you staying in that village?
Yes, my lord, I am the villagers of that village. I produced the documents.
Okay, no stay. Next. 80.
15/7, 79.
Re-notify.
Petitioner, my lord.
We'll have it some other day.
My lord, notice has to go, my lord. Notice may kindly be issued. No any interim prayer, my
You appear, who appears in this?
lord. Not government, my lord. It's a body, local bodies.
Okay, we'll re-notify.
Notice has to go.
No, we will see some other day.
Yes.
Re-notify on. 80 also re-notify. Who appears in 80?
15/7.
Pleadings are complete.
80,
80 re-notify. 81?
23/7, 81.
Pleadings are complete in.
Re-notify.
23/7.
And password. And password.
Okay. Yeah, have you got this?
Yes, my lord.
Just give it to him.
Yes, my lords. My lords, this is the second time I'm serving. With due respect to this honorable court, please, my lords.
No, my lords.
He does this every time, my lords.
It's all
a
right,
dilatory-
ma'am. We will record it. We'll make a part of judicial order. Just say this. How many applications you are serving on him?
She has to serve the main petition, 3 memos, 1
My lords,
reply
I've given him
and
the
1
entire,
more memo.
my lords, I've given him the entire petition with the annexures and the memos. There is also, my lords, for the thing of this honorable court, my lords, I've made 2 copies if my lords can go through.
Give it to him.
And there is even the acknowledgement, my lords. I've sent everything. My lords, these are his.
Why are you joining
dilatory-
issue, ma'am? Give it to him.
Please take it. My lords, these are his dilatory tactics, my lords, just separating me from my child. My lords, my child was with me till she was 7 years, my lords, from the birth till today, my lords. But in between, he has made these kind of false submissions in front of the family court. Confusion created between the jurisdiction. My child that was with me in West Bengal, Malda, my lords, he brings an IA-8 imposing a condition that the child should not be shifted from jurisdiction of Bangalore. My lords, I'm not getting any maintenance from him. So I'm working in Malda. So I'm forced to hand over the child to the father. And for the last 2.5 years, my lords, every interim custody order that is granted to me, at least for the vacations from the family court, is deliberately frustrated by the father, my lords. The day he has to hand over the child to me at Malda, I'm waiting there. He comes before the Honorable High Court. Say, for example, tomorrow the child has to come to me. He comes today before the Honorable High Court, makes his false submissions, and ensures he gets an ex parte order. I have put everything in this petition, please, my lords. And at one place, he gets a stay, my lords. For the last 3 vacations, my lords, I have not been able to have any kind of an access with my child, my lords. The worst is, my lords, I have made a compilation that he's been a repeat offender. My lords, in my contempt petition at page number 106, kindly see the scandalous remark he has made for a sitting judge, my lords. Page number 106. Please, my lords.
Just say this.
It's not complete still,
We'll
my
learn a
lords.
counsel for this.
It's.
My lords, everything.
1 minute. How do you say it's not complete?
Because this is not the main petition. It is only.
We don't know. How do you know that this is not the main petition?
Because I have a copy of the main
So
petition.
then why did you say so? It's not.
Which is not complete. The annexures are missing.
Ma'am, just check it. We
Please
don't
see.
want anything. This
Yes.
controversy should be there.
Please see, 108 to 121. I'll pass on the.
Show it to her.
Please.
My lords, what has happened? innumerable numbers on this, my lords, and there's one in ink, which is a little light. That does not come in the Xerox. On the last thing that I've sent it to him, my lords, I've again made a Xerox of both these papers and sent it to him. 112. It's in light ink, my lords. This is not coming to the.
And she's adding annexures. That is also not given to me.
My
This is
lords,
the certified copy.
My lords, the whole
That is
thing.
my grievance.
If any court officer can check, my lords. If there's any discrepancy, my lords.
They are surprised that these things are issues.
These things
to
should
be-
not happen. Yes, my lords. I'm also surprised.
It's all between both of you, sit together and work it out.
Please,
We don't want to hear from you, neither from you
Yes.
that you have not given or he has not received.
My lords, you can trust me, please, my lords.
They are surprised that these things are issued to be
She's
decided.
It is
inserted
deliberately
here
done,
and
my
she's
lords.
she's
My lords,
not giving me
every
copies.
day of delay. My lords, I
Absolute
have to be
false
very-
submissions till
My
now.
lords,
I will do
my
exposition
lords,
of the
page
truth.
number
If you
67.
had not given, apply a certified copy, take it.
But they do not give the annexures, my lords. That is the onus here.
My
I
lords,
will demonstrate.
please
This is the
trust me.
copy she has given.
My lords, please trust me.
And she's recording
I
and
don't
she's
have to.
forcing the accused
My
to
lords,
actually take the copy without serving it on us.
My lords, it's, the
Five
order is very clear
extensions.
that it has to be given by hand to the respondent. Kindly see the photographs,
That
please,
is
my
the
lords.
office objection,
My lords,
which has been raised by the registry,
Lords, the
that she has not
photographs will
served
prove.
me.
The photographs will prove, my lords. False submissions to the court. In fact, the family court is recorded in page number 67. Please,
That
my lords,
is what
that
we
the
are fighting,
advocate
that there is
known.
contempt against her,
He's
your
known for
lady.
making false submissions. My lords,
And
this is the reason.
she does not do this in
Please allow me
any
to
of the
talk.
cases. She's
Please allow me to
always
talk.
filing
My
without
lords,
serving us.
my lords,
And she comes up with this. Last time she had the audacity of giving it across the bar and the bar
language,
rejected
please,
and
my
said,
lords.
no, you will serve it and then you give it to us.
I have
This
immense
happened.
respect for the court, my lords. I don't want to
She
waste
does
the time
not
of the court,
respect
my
the
lords.
court. It has
This
been
is done
recorded. She has
deliberately.
no respect for the court. Your
Deliberately, my lords. If you see, my lords, if you see the complete
108 to
petition,
122, she's jumping.
Okay, we'll get up.
Please.
Ma'am, my lords, a date, please, my lords.
We are giving you a date. She will give you a date, pre-notify, just say that.
Very grateful, my lords.
Mind your tongue and submit here now. Hey, don't talk. Need mucha.
Court officer, ಅದು 4 PM bench ಯಾವಾಗಿದೆ? Court officer? Court officer, I can't hear you. Court officer, is the 4 PM bench, the cause list going to be taken up?
Shri George Joseph.
My lord, appearing for the respondent, my lord.
Yes,
My lord, I request for a short
we have to
accommodation.
release.
I thought it was listed at 4 o'clock. I assumed possibly it is getting.
Not get time, you know. Just say that we are releasing it, ma'am. Just say that this appeal is released from Parthad. Be listed before the roster bench, subject to the orders of the acting Chief Justice on the administrative side. On, give the date, ma'am.
12/6.
12/6. Thank you.
Grateful, my lord.